Any mention?
25.
Yes.
Lordship,
Yes.
I beg to mention item 56.
26.
56.
It's a joint mention, my lord.
What's this matter about?
Your Lordship, it's about a disputed land, Your Lordship, that the PHE has laid some water pipelines without my consent, Your Lordship. PHE Nongson
You're for the petitioner.
acquiring my land without my consent
You're for the
and laid.
petitioner.
Yes, Your Lordship.
I thought you're Mr. Walong's junior, no?
Yes, Your Lordship.
You mentioned whose behalf?
Well, Mr. Wall.
55
56, Lordship.
or 56?
Yes.
56, my lord.
Yeah.
No objections.
Okay, yes.
Highly obliged, Lordship.
So, yes. Yes, make it quick.
Your Lordship, I'd like to mention item number 53.
53?
53
53 and 54
and 54. Your
Where's
Lordship,
your senior?
she's on leave, Your Lordship. So,
I can see that.
1 week.
What to do this matter? He's on the last leg. Yes. When?
After the 15, Your Lordship, or after 14.
You take a date from this. Better of these matters, yes. Yes.
Item number 42, my lord. This matter was heard. We are supposed to file the written argument. So my written argument is ready, my lord.
42?
42, my lord. Vidyadhar, Dr. Vidyadhar, my lord.
File it.
No, what happened, my lord? There's some difficulty to contact the client. I just want to show it to him. There was
Mail it to him.
last week there was a bereavement in his family, my lord. So for that only, I will file it on Monday, my lord, positively.
Will be ready. We'll file it today, my lord.
And you file it after 1 week also.
Yes, my lord.
My lord.
Thank you.
After 1 week of filing of notice and submission.
May I please, Your Lordship? Lordship, I beg
Yes.
to mention item 51.
51.
51.
Yes.
2 weeks, my lord. Similar prayer for
No objection.
Similar prayer for item 59.
Number?
59.
59. Who's the other side?
I'm there, my lord. For the
Words.
private respondent.
Okay, yes.
And for the state and for the matters.
Yes.
Lordship, obliged, my lord.
Lordship, I beg to mention item number 60.
So I think where's Mr. Khera?
Yes.
Why are you taking time today?
Your Lordship,
Matters,
Almost heard.
yes.
Your Lordship, we're awaiting the reply on our lease extension application.
No, that's not an excuse. But this matter is different. The lease is over. It's been renewed.
So even he submitted with the delay also he has submitted.
Where's your senior colleague? Yes, yeah,
Yes.
Mr. Khera.
He's currently out of station, Your Lordship.
I'll just keep this matters hanging like this. 1 week.
Can you allow us 2 weeks time?
1 week. We won't give you more than 1 week. Okay. Yes.
Much pleasure.
And the pray also.
My please, Your Lordship, I beg to mention item number 50, Your Lordship.
Number?
50. Praying for 2 weeks' time, Your Lordship.
No objections, my lord.
Yes.
May I please, Your Lordship? I beg to mention item number 55, Your Lordship. I pray for 2 weeks' time, Your Lordship. No objection, Your Lordship.
Very difficult, all but yes. Yes.
Highly obliged, Lordship.
May I please, Lordship, I beg to mention item number 57, Lordship. 57.
No more adjournments now after this. Yes.
No objection, Your Lordship.
No objections always. What is this? Yes.
Much obliged, Lordship.
After 6 weeks.
2 weeks, Lordship.
Next time adjournment will give long adjournments. Yes. So you won't have to ask again. Okay. Yes.
Much obliged, Lordship.
Your Lordship, I beg to mention item number 58. I'm praying for 1 week time, Your Lordship.
58. Yes, who's Dr. Mozika? R. Chaudhary and Chaudhary. What?
This is a doctor seeking VRS in some reference.
That can be disposed of today.
I placed instructions, my lord. They're supposed to take instructions.
He's on leave. My lordship, my senior, he's on leave.
You get instructions to tell a senior before the next date, yes.
Yes, lordship.
After 1 week, yes.
Much obliged, lordship.
Call out this.
Please, Your Lordship. I beg to mention item number 52. I'm praying for 2 weeks' time, Your Lordship.
Yes. When? 3 weeks?
2 weeks.
4 weeks? Yes.
Supplementary list item number 1.
Huh?
May it please your lordship. Lordship, here the petitioner is the wife, first wife of the respondent number 3.
I should go for mediation actually.
Lordship.
But I think how can she claim family pension now? Separated.
My lord, she is the first wife. Her name reflected in
you
the.
Take, you heard Mr.
Yes, lordship.
Sheikh issue notice. Ms. Y. Banks present on behalf of 1 and 2. Except notice. Notice issue number 3 within 3 days. List up to 2 weeks.
Also,
let them appear.
Item number 2.
Fresh matter.
Yes, ma'am. My lord, actually, initially we have approached this honorable court by way of civil revision. So at that time, the caveat was discharged, lordship, and we have withdrawn due to some defects. We have withdrawn and filed afresh. So we have already served notice to the respondent. Lordship, here in this case, I have instituted the suit in the year 2024, and the presiding officer of the subordinate council court has directed both the parties to maintain status quo within the suit land.
Yes.
So, my lord, and was confirmed by the order dated 13/3/2026. Against this order, my lord, the respondent has approached the lower appellate court, and the lower appellate court, my lord, has set aside the status quo order and granted possession over the suit land to the respondent. At the same time, my lord.
Now, who was in possession actually?
Actually, we both claim possession over the suit land. This is a case of encroachment, my lord. There's no denial, both of us having lands adjacent to each other.
Okay, okay.
So, my lord, the trial court has directed the parties to maintain status quo because there are some construction over the suit land. But what the appellate court, lower appellate court has done in this case, my lord, has allowed the respondent to create a third party right over the suit land.
Why, they sold it to someone else?
No, my lord. Alienate to the Dorbarshnong, to the village authority.
Okay. Let's see the order. Where's that part, operative part? Page. You're ready for admission hearing today?
Yes, yes, Your Lordship.
The first time it's come, correct?
Yes, ma'am. Page 34, my lord. This is para 17.
Page 34.
Of the impugned order. Page 7, para 17.
Yes. Yes.
The suit land claimed by the respondent plaintiff is a vast area of land having an area of so and so, where possession of the appellant have been substantiated by material facts. Hence, I am of opinion to grant status quo. Opinion to grant status quo order restraining both parties from raising any construction within the suit land will amount to dispossess and depriving the right of enjoyment over the suit land where they used to have continued possession over the suit land, disputed land. In view of above, I am satisfied that the respondent have no primary case for grant of status quo order.
Now, who's making construction?
The respondents, my lord. Kindly come to annexure 12, page 10.
Page 10?
Oh, 104.
104.
Relevant page is 106. My lord.
Yes.
Having heard the submission and for proper perusal of the same, it is found that the appellants are contended that
Which order is this?
This is order dated 10 April 2026.
Yes.
106. Having heard the submission and for proper perusal of the same, it is found that the appellant are contended that since they are in possession of the land, hence the order restraining them from walking within the suit land is grave injustice towards them. The respondents' counsel, on the other hand, being contended that the status quo order is for protecting the suit land from any alteration. Hence, I am of the opinion that.
Now, the thing is that there's a school here on this property also.
My lord, this school was given. This was given for construction in this suit land after the status quo, my lord.
By whom? By the respondent?
By the respondent.
Is that correct?
No, Your Lordship. Your Lordship, previously there was a title suit in 2009 whereby I have instituted against the Dorbar Shnong. The subject matter of the dispute in the previous suit land is over a plot of land for construction of a school, Your Lordship. However, it was withdrawn in 2024 April on the basis that the new executive member of the Dorbar has been newly elected, and it has been resolved because the school has been allowed to be constructed under what we wanted where the school to be. So after we withdraw, they filed a fresh suit. Now, after they have filed a fresh suit, they have come on the.
No, you mean to say that during the time when the suit was withdrawn, in the intervening period, then the permission was given and started construction of the school.
Your Lordship,
you just want to know whether after status quo orders were passed by the trial court, whether there was any construction going on, or whether you give permission after the status quo order, or whether these things are, pre the whatever happened before the suit.
Your Lordship, after they have filed the application under Order 39, Rule 1 and 2, Your Lordship,
I filed for breach of the status quo order
in the year in December 2024. At that point of time, Your Lordship, we have not got any sanction from the government to renovate the existing school. So, Your Lordship, we got the approval from the government. However, Your Lordship, they have not enclosed anything in this demo.
So, where about it in the lower court proceedings?
They have admitted.
Bring that on record.
They have not disclosed anything, Your Lordship.
With regard to we'll call for the record. Yes. Yes. We'll admit it consideration. Heard Mr. Constable of the appellant. Mr. Sorry, your name again?
R.S. Maliang.
Yes, R.S. Maliang is present on behalf of the sole. How many respondents are there?
Two respondents.
Two respondents. No further notice required. Stop. The appeal directed against directed against judgment order dated 34/2026. Passed with the court when it decides the council court Shillong. So, name this appeal number so and so. Stop. The grounds set out in the appeal is that on an introductory matter, the London Lower Appellate Court advocated status quo order dated 13/3/2026 and instead has granted injunction in favor of the respondents when no application for grant for any injunction been filed by the responsible trial court and no such prayer made for the Lower Appellate Court. Further, it is submitted that by the vacation of status quo order and allowing the respondents to continue with well, vacated search for the third party interests have been created, which will change the nature and character nature of the suit land. Stop. I therefore praise that the search order be passed at this stage. So pending hearing of the appeal, the appeal. With Ars Malingyang, learned counsel submission that
the school, Your Lordship, has already been constructed now, because we have
that the construction is complete.
No, Your Lordship, under process, Your Lordship.
Yes, that,
It's a deliberative.
we don't deny that.
School,
You don't deny that the construction is going on in that land now.
Your Lordship, the first appellate court, Your Lordship, has granted on the basis that we are in possession. We are
How did
already
they come
in
to
possession.
finding of possession then?
Yes, Your Lordship. Your Lordship, they have not enclosed the executive magistrate order, Your Lordship, where there's a proceeding under 145. And magistrate, Your Lordship,
Anyway,
has
I think the Asman
declared possession on my behalf.
In reply submitted that the construction to complete is present on the sued land, and that the appellants have not brought on record certain vital facts with regard to the factum of possession. So he therefore submits it as the therefore submits that the matter be not admitted and be dismissed at the stage. So, having heard accounts of the parties, it appears that the matter deserves further consideration, especially on the question as to whether, after status quo orders were passed, the respondents had granted permission to construct the school, thereby creating third-party interest. Accordingly, it is directed that until the next date, strict status quo to be maintained and no construction should be conducted in the suit land. We will hear it urgently. He has called for the records. He is immediately on his records.
The school may not be enforced, Your Lordship, at the moment because it's still under construction.
No, we have to at least for 1 week let records come and dispose it of.
In the first place, also, Your Lordship, the ex
Three.
parte order they have obtained by mispresentation of facts. We
That
have
you
done-
argue will list it for admission hearing again to admit it. Yes.
May I please, Your Lordship?
Yes.
Lordship, yesterday I was saying about the transfer order, the impugn order, Lordship. It's
Yes.
very vague. Why I'm saying vague, Lordship? Neither it shows about the exigency, neither it shows about. It says about the temporary detail, But Lordship, there is neither such clause to say that there is in the transfer policy to say about a temporary detailment. And Lordship, if we see in this only, Lordship, it does not speak about any benefits, no TADA. If it is a tour, if we take it as a tour, then all the expenses has to be borne by me alone, Lordship. And if it is a transfer, then Lordship, then that has to be mentioned out here. All the TADA will be borne, even if they are saying that they are going to pay something honorarium, that has to be made it in there. Now, Lordship, again, another thing where they say that exigency. To say this exigency, Lordship, they should have come up with, have they received any kind of order from the competent authority? The chairman is not the only person, Lordship, to decide on this. But the order here is only from the Deputy General Manager. It has to have the order. Now, Lordship, on such a thing, once you have a policy framed, you have an expectation that you have a legitimate right, Lordship, on that. Now, they should not have framed this policy. They say that this is not statutory, not mandatory. But Lordship, in their affidavit, they are relying on all these rules that they have framed, Lordship. And
my only question, was whether the transfer policy it will come into play at all in this matter.
Lordship, that is
because it's not a transfer per se. It's just a
Lordship.
deputy. It's not deputy. It's a, what do you call it? What's it termed as here? What have you said?
they are saying it's a temporary
detailed.
Yes.
Temporary detail.
Temporarily detailed.
Now, Lordship, that
Sorry, I don't think.
Lordship, if we say temporary
you give all the
detail,
benefits of whatever temporary duties that the
Yes,
doctor will
that
decide.
will give it.
Lordship,
Whatever
but,
is applicable.
my representation also till date they have not considered it, Lordship. They said because the CHRO is not on station, so it cannot be considered. At least till my representation is considered. Lordship, I will just place Lordship's judgment only. Lordship had taken in this only. This is in WPC 258 of 2018.
Yeah, that is. Yes, that is.
Lordship, it is mentioned here even in their term policy only about the what are the suffering when what is the treatment for special disease. Special disease has been explained. Lordship has taken note into this also, Lordship, in this judgment. Lordship, another one is I'm also placing this Registrar General versus High Court of Madhya Pradesh and another, Lordship, reportable. This also, Lordship, this also I'm relying on para 40 and page, that is page 80. Lordship, we have a expectation. Lordship, once you have framed a policy, we have an expectation in the fag end of my service, Lordship.
How much longer is here?
Lordship, 9 months only. And all the time also, I was not being here only, Lordship. I had been transferred to various 6 locations, Lordship. And I have been dutifully doing with an unblemished service.
That. You see, just come back to the transfer order. We saw that, right? Where's the transfer order? I mean,
that is the page 22.
Yes. What does it say? It says when you attach so and so for medical and health services of so and so to. See, we can't. This is a reason. This is a reason order. It's not a question of any malafide or any punishment or anything attached to it.
But Lordship,
and it's not even as per if it's per transfer policy. We can understand. It's only for he'll return back after 3 months.
He still remains under the posting strength of Shillong.
Yes.
He is not out from Shillong.
But Lordship, the problem
due
is
to medical emergency, Your Lordship, because that project.
Sorry. Anything else?
Yes, Lordship. At least this to be considered only my at least still that consideration of my representation, Lordship.
What sickness they have? Type 2 diabetes.
Yes, Lordship.
Hypertension.
That, Lordship, and then and these places that I am to be transferred, that for even it's a temporary detailment, Lordship. These are 3 places. They are in the terrain, and for this project, I'm sent to this Tata, Hio, Nayang. There are 3 different places, Lordship, which is 10 to 25 kilometers far. And Lordship, Arunachal is such a place where there are landslides, and now also it's happening only, Lordship.
Yes, everywhere.
And medical facilities here, Lordship, it's difficult for.
Yes, Mr. General.
Yes, Lordship. Lordship has already gone through the transfer order. So-called transfer order, and I have filed my counter to that. Your Lordship will come to paragraph 5 at page 4. That the impugned transfer order dated 22/6/2026 is not a transfer order. By the impugned order, the applicant who is presently attached to Corporate Office Shillong is temporarily detailed at so-and-so project with effect from 1/7/26 to look after the works related to medical and health service of this project and to coordinate with district medical department as well as defense medical department located nearby to ensure better medical facilities at Tato. It is most respectfully submitted that the applicant writ petitioner continues to remain in posting strength of the Corporate Office Shillong, and in that view of the matter, the writ petition itself is totally misconceived and not maintainable. And the policy, Your Lordship, if it all applies.
Come to play here at all. It's not just for the policy. It's not a transfer. We'll pass orders then. Yes.
Lordship. Lordship, I'll place one more judgment, Lordship.
Please.
This has relied on this Registrar General.
Only one.
Yes, sir. It's a matter disposed of.
Yesterday, Your Lordship. The other points are covered by yesterday's judgment. There is nothing remains.
Are you aware of that judgment?
Yes, Lordship.
Yesterday's judgment covers
Lordship,
all the points.
But then again, Lordship, in yesterday's one and in today's one, there is a vast difference, Lordship. That's what the representation was already rejected, Lordship. And whereas in mine, my representation has not been taken into consideration also, Lordship.
This is your judgment, Duban Kato versus Tiran.
Duban Kato also I'm relying, Lordship, and I'm
Which
giving the
part?
para 11.
Yes.
The one.
See, this unless a traffic anyway.
Your Lordship, only one paragraph 10 of the S. R. Abbas judgment, which says that we are not even required to justify the reasons. Paragraph 10. Here, this was a case when the husband and wife were, as per the policy, were required to be transferred at same place, and
you can't shorten the tenure to 2 months.
Lordship, it is not in my hand.
Yes.
But he can always write to the department.
That is here.
Write to the
Lordship,
department.
we'll be explaining if I have misconceived, Lordship.
He is still under the posting strength of Shiva.
No, that is no quarrel with that.
Highly blessed.
Yes.
Daily list item number 1.
Give it to her. Obliged, Lordship.
Your Lordship, I'm praying if this matter can be taken up after 2 weeks, Your Lordship.
Why?
Mr.
Who's appearing for the respondent?
Lordship, I am appearing for respondent number 6, Lordship.
Yes.
Mr. Paske is on leave, Your Lordship.
This is a contempt.
No, Your Lordship,
Oh, no,
it's a review.
Yes, yes. Okay, yes. After 1 week, as the arguing counsel is not available.
Yeah, please, Lordship. Petitioner may serve main petition copy.
I'll serve them, Your Lordship.
You haven't even got, do you want to serve a copy to them?
Yes,
No, Your
Lordship.
Lordship.
Why?
Item number 2.
The brief is now with me, Your Lordship. So.
Item number 2.
Obliged, Lordship.
Yes.
Well, in this matter, I am aggrieved by the impugned order whereby the judgment and decree as well as the execution proceedings was set aside and the matter was remanded back to the trial court.
The today for the eviction hearing?
To the trial court, Your Lordship, to consider the matter on merits.
Okay. Yes.
My Lord, in the year 2012, I have instituted a suit for eviction.
What's the status now of the property? Now, is it on occupation? Anybody occupying it?
The respondents, ma'am.
They were in occupation.
Yes, ma'am.
Then we admit this matter.
Yes.
Call for the record. Yes. Yes, Mr. Paul.
I appear respondents.
Yes.
Well, it's just two relevant dates would be relevant for this purpose. It's a very short matter, Your Lordship.
We'll admit it. We need to see the records because the thing is that the defendant number 3 never appeared. The other two they expressed no interest. The matter went. Then the decree was passed in favor of the. What I see just now in favor of the appellant, and in execution proceedings. When you file for stay of execution, the whole matter is taken up. Yes.
Your Lordship may kindly see who are the parties before Your Lordships.
Yes.
Respondent number 3 is not relevant here, Millets. Your Lordships may kindly just have a look at Millets, the array of parties.
Yes.
Millets, the respondent number 1 and 2, the defendant number 1 and 2 in the suit, Millets, are the respondents before Your Lordships here, Millets. They've made only us the parties.
Where's number 3?
At
the
page 2, Your Lordship.
Yes.
My Lord, the appeal was filed by respondent number 1 and 2.
Was by 1 and 2?
Yes, my Lord. Only those two have come before
Here, the limited issue is this, Millets. After the suit was filed, Millets, by the order dated 11/12/19, which Your Lordships would find at page, well, it's 77 and 78.
Yes.
78 is the relevant portion. Millets may kindly have a look at it.
Yes.
Millards, we had filed, we said, Millards, we do not want to contest the
Contest,
suit, and
yes.
our names struck off.
Yeah.
So our
Yes.
names have been struck off.
Right.
After that, Millards, the learned trial court proceeds to pass a decree against us when we are not parties to the suit.
That is the
And
question.
directs my ejection. Your Lordships may kindly have a look at page 132.
Then we will have to admit it, Mr. Paul. No. Your third.
Para 136. Page 136, para 56, my lords may kindly have a look at it.
130? 136.
132, my lords. 132.
Okay.
Para 56.
Yes.
Your Lordship may kindly for ejectment and eviction of the defendants, the men's agents, heirs, so and so. And my lords, this order is passed against whom your Lordships would find at page 79.
No, even then, since he didn't contest the suit, whatever consequential, so whether it doesn't matter how the decree will affect you, we'll examine it.
If I'm not, Malaj, what I'm saying is, if I'm not a party to the suit, you cannot pass a decree against me, Malaj, and then force an execution of the decree.
See, you cannot. You might not be a part of the suit. You might be there as the agents of the number 3 who are contesting the suit.
No, Malaj,
that will have to be gone on to. Yes, and in the executive proceedings only. Yeah, and the trial de novo has been ordered. We'll examine that. Yes, sir. Heard, but
You know what trial part, Malaj, I cannot defend because
yes, then
there is some
yes.
in that order.
Yes.
But insofar as Malaj, the decree as against me, Malaj, that is something your Lordship will kindly appreciate, Malaj. If I'm not a party to the suit, how can there be a decree against me?
Yes, heard.
The remedy of the petitioner would have been elsewhere, Malaj.
Our learned counsel, the appellant, also Mr. K. Paul is a counsel appearing on behalf of both the respondents.
1 and 2, Malaj.
1 and 2. On perusal, the matter deserves consideration. The appeal is probably admitted. All further records listed immediately after receipt of records.
Item number 3.
Please, Your Lordship.
Yeah.
Your Lordship, in this matter, the appeal is still pending before the division bench.
Matter is pending. So, list of as the an appeal pending against the order stated to be violated. Yes.
Item 3 and 4 are connected, Your Lordship.
Before the division bench. This is matter after 6 weeks. It'll be over by then. Yes.
Obliged.
5.
Yes. Yeah.
May I be Lordship?
Yes.
My Lord, this is the contempt petition against the order dated 18/3/2025. The
Yeah,
benefit of clerical trade in Assam Rifle.
The file review, my lord.
And
Department.
my Lord,
SLP was dismissed. The file review. There was a defect.
SLP dismissed review. That will go nowhere. You comply.
My humble prayer before your Lordship, the SLP was dismissed, my Lord, on 5th January 2026, my Lord.
5th January 2026. Yes. And when did you file the review? Review is lying in
filed the review, my Lord, 27
lying in defect
February
stage. Lying in defect stage with Dr. Mazika.
Defect has been rectified now.
Rectified. There's no sense. What instructions do you have?
Oh, that's the only steps. Nothing beyond that. Just give us some time, my lord.
You file affidavit then.
I'll imprison them, my lord. Either comply or
yes.
Expedite the review.
The review petition was filed on 27 February 2026. My Lord, but
that doesn't matter, Mr. Kumar. They have to comply. Yes. How many petitions are involved? How many petitions are involved?
611, my Lord.
611. What is the implication? Final implication?
200 crore, my lord.
200 crores.
100 crore.
That is a problem to comply. Is that a one-off case?
I don't know.
Financial settlement, my Lord. Financial settlement, my Lord. It will come later. Let's the rank may be given first, my Lord.
Yes, Dr. N. Mozika today has again submitted that the review application has since been filed after dismissal of the SLP is still pending consultation for the Honorable Supreme Court. Mr. V. Kumar for the respondent, for the petitioner, has objected very strongly and submits that compliance should be ordered. Compliance should be within
4 weeks time, 3 weeks time.
we will just, in case of justice,
We will file affidavit.
you file affidavit.
2 weeks enough, my lord.
Yeah, the affidavit should be filed by the respondents. So it's up to 4 weeks. Yes. You better file it.
Well, we'll have to comply. Only financial implications are sure.
That is why we give 4 weeks.
And not only this, another batch is next item, my lord.
How many?
Next item, item number 7, my lord.
How many petitioners here?
Here also,
There are 220.
240.
My lord.
240. And the final implications
There are-
around.
There is another 40-50 crore. my lord.
Yes, same order.
Number 7.
Review file here also.
No, my lord, here the writ petition.
This is the writ petition, my lord.
7th.
And next matter.
6.
Yes, 6.
Deep your lordship.
Mantan ke file. Mantan ke kena. Percing apa yang percing? Yes.
Specific instructions with regard to the petitioner. The matters pending before the finance, after the receiving the concurrence of the finance department, it will be placed before the cabinet.
No, the thing is that what steps have been taken?
Steps, everything has been done.
No, not your general policy or decision. What's with regard?
Exactly, my lord. This is specific with regard to the petitioner.
Petitioner.
Yes, because it also includes others, but this is specific with regard to the petitioner. But I have marked that para also.
He retired, still serving.
Retired.
He's retired.
When he retired?
Retired in the year 2000. Let's see.
Then you have to be accepted.
30 November 2023. On 30 November 2023, it is from service. Retired. It is from service.
But I thought there's already a policy decision in place with regard to not teaching staff.
That was, Lord, these names are never forwarded. This is
No. Regard non-teaching staff of this is a council school, correct?
Yes.
The policy is already in place.
But my lord, these require cabinet approval, my lord. That is the only
judgment of this court.
Is there are many.
There are several cases, my lord, which also includes petitioner's case, my lord. Now these services have not yet been regularized because it is pending the cabinet approval, my lord. That is the only difficulty.
Today, Mr. K.P. Prasaji has produced a status report. It's not dated.
It will be dated in the letter.
Yes, yes. Under cover letter dated 3rd July, so and so, wherein it's seen that the matter of graduation of the writ petitioner and other non-teaching staff is currently being taken finance department stopped, and thereafter to be for the cabinet stopped. It is noted from the status report itself that the letter has been sent since 15 January 2026, but till date it appears no final decision has been taken. Have you filed affidavit here?
My lord, respondent 1 and 2 have already filed.
Yes, sir. This is a matter after 2 weeks for further specific instructions. Otherwise, we'll ask the people to come here. Get back.
7.
Master Lordship.
This is yes, Mr. Kumar.
My lord, this is also the benefit for clerical trade in Assam Rifle, my lord. Benefit of your commission. And this is the covered case, my lord.
Yes.
And it has been disposed of on the same line that the Honorable Division Bench has disposed of the matter, my lord.
Where's the earlier order of this court?
My lord.
Yes.
Annexure 8, my lord.
But I'm praying this matter maybe sometime maybe again. But otherwise, again they'll file contempt order. The same situation.
Are you disposed of after 1 week?
It can be disposed of, my lord, the same way.
Yes.
Annexure 8 is covered, man.
See matters how many? Just for mercy.
Come in batches now to get financial sanction and to implement the different.
Must all of you own doing? Yes.
You are saying.
But till yes, thousands of them have been.
Thousands.
Yes, after 2 weeks, Mr. Kumar.
There are advertisement for
advertisement
for riflemen. They applied, got selected. They joined after 10 years, 15 years of filing case for application.
Item number 8.
My lord, deeply lordship.
Yes. For rejoinder? Are you filing rejoinder or not?
Petitioner. Yes, sir.
You filing rejoinder?
Yes, sir, for 2.
How much time?
2 weeks.
My lord, I'm applying for statement. And for the respondent number 4, lordship.
Yes, sir. 2 weeks time must be allowed for rejoinder. This is thereafter and so on.
Right.
9.
May I please, lordship. Lordship, we have received affidavit filed by the opposition. We'll file the rejoinder, lordship. 2 weeks time may be given.
Yes, sir. As L coach, please have allowed 2 weeks time to file the rejoinder. The affidavit filed by the MCL respondents.
Please, my lords. We've already filed it.
10.
Response allowed, no?
Please, lordship. This matter can be listed for hearing. Yeah? The pleading is complete. I have filed my rejoinder. Lordship.
You filed?
Lordship, I have filed.
Party subject pleading is complete. Accordingly, it's a matter for hearing after 2 weeks.
Lordship. That's please.
11.
On this matter, I'm praying for some time, Lordship. Rejoinder, Lordship.
How many times you prayed?
Last occasion of need and deadly, Lordship.
Straight further, 2 weeks time allowed.
Lordship.
Rejoinder.
12.
Lord, I'm waiting for the instruction, my lord. It's again the gratuity, and again that agreement coming to play, my lord.
Which agreement?
The agreement between the district council and the government. All the salary and gratuity will be paid by the.
Has the amount been sanctioned? With regards
the amount is
The
sanctioned.
sanction is there, lordship. It is 4,70,400. Annexure 9, my lord. It is page 9.
Let me complete the instruction, my lord, so that it will be clear whether state also has to.
You don't have any funds.
At present, we don't have, my lord.
Will
I've shown, my lord, that agreement.
Mr. SD today pays for further time to obtain instructions. It is noted that the sanction for a gratuity amount has been made since 13/10/2023. The expected next date that specific instructions will
It will
receive.
come after 3 weeks.
Yes, obviously, but then you clear it. This is
Well,
right. Yes.
Must please, lordship.
13.
We have filed the affidavit, your lordship.
Lordship, I'm praying for a week's time, lordship, for filing our affidavit, lordship.
7 to 10 and 12.
Lordship.
You already filed yours, state.
Yes, your lordship, we have already filed.
Yes, sir. Mr. Chanda. Correspondence number?
7 to 10 and 12.
7 to 10 and 12. That's matter file 25. We'll
The affidavit is otherwise.
What's the matter about?
Lordship, this matter pertains to retrospective application of the promotion, Lordship. They are seeking promotion retrospectively from year 2018, Lordship. Whereas the DPC was constituted in the year 2023, Lordship.
Yes, as paid for the 2 weeks time allowed to the response 7 to 10 and 12 to file affidavits just thereafter.
14.
The 14 and 15 are
connected.
Arbitration petition for appointment of arbitrator.
The list?
Lordship, we have already last time.
The instruction is to file an affidavit, my lord. One we have sent for signature.
You get a name, we'll appoint arbitrator. Why you don't need to file affidavit also? Just file it along with you. What list is running now? From the
There is no list now. Lordship can appoint any retired judge also.
We have already given.
Clause 70 is here or not?
Lordship, clause 70 is there.
Clause 70 is here.
Lordship. So, Lordship, we have already given the list that.
But they are not insisting on engineers.
Then Lordship may appoint someone retired.
You want to file affidavit or not?
You also appoint
For the
a
record.
retired judge.
Yes. What's the amount in contention?
This is small.
Amount is the two matters, Lordship, in
This
item,
is,
item number 3, Lordship.
5 crore 61.
Lordship.
That was the total contract, my lord. The disputed amount is
2.61, Lordship, is the additional claim that we are asking, Lordship. In item number 14, Lordship.
So just a name, which is retired judge.
Lordship, then we may take instructions today, then Lordship may fix it on Friday.
We'll post on Friday. Yes.
Lordship.
Parties pay them allowed to copy instructions up to
this Friday.
The
Monday, Tuesday.
Parties pray they allowed to do instructions as to the
Retired judge.
To the retired judge who is to be appointed, we suggested for appoint arbitrator in the matter. Just on Monday, yes.
Lordship.
16.
This is also here also write appeal SLP has been dismissed. Man.
SLP dismissed 16 to
They are filing a review now here also. But this is the individual matter. There are not much financial selection appointment of one person.
This one then you comply. Why you not complying?
No,
soon, like when all these matters will taken on one day, all your top brass will have to come here.
But some observation will be given. Well,
observation that top brass have to appear.
Not for appearance matter today. If not complied with something.
Yes.
3 weeks time is not complied with.
It is by order dated 15/6/2026. This court had recorded that the SLP referred against the judgment of this court had been dismissed in 16/2/2026. Today, also when the matter is taken up, there's no affidavit on the record, no any instruction with regard to compliance of the orders stopped.
Rather, instruction is the process of filing a review petition.
When the matter is taken up today, the only instructions which have been offered by the DHI is that a review has been preferred against the dismissal stuff.
Is in the process, man, not at report.
This court, there's a process of being filed. This court notes the submission, however, also expresses displeasure with the conduct of the respondent stuff. It is made clear that on the failure of to comply with order within failure to comply with order, that the next date the personal appearance of the contemners shall be ordered and proceedings be initiated against them in accordance with law. Yes, just after 4 weeks. Yes. As of course, heard Mr. V. Kumar present on behalf of the petitioner. Yes.
17. Deeply lordship.
17.
Well, 17 to 23 as those lump sum compensation matters. When are those coming? They are coming on.
These are permanent disability.
Yes, my lord.
Disability lump sum, my lord. Kindly see last order, my lord.
Till 23, my lord.
My lord has.
Have you filed where the chart?
But the chart we are preparing, my lord. The other matters are coming on 15th of July, my lord.
On 15th of July.
15th is but Friday only.
Will the chart cover all these other matters also?
We'll make a comprehensive chart, my lord.
Yes,
covering all the matters.
And Mojika today submits that as other connected matters are
15th is day after tomorrow.
15 July, the incident matters be placed together to enable him to file a comprehensive chart that will cover all the cases. Yes. Appraisal.
24.
My lord, item number 24 to 27, non-communication of ACR, my lord. And in this matter, my senior has also submitted in the last time that they have placed the chart, my lord.
But I'm praying for
Kindly
some
see
more
last
time.
order, my lord.
I'm praying for some more time.
To get the chart.
To make a chart.
Yes, Dr. Muzika and JGI, but the respondent prays for further time to place a chart to enable this court to dispose of all the matters jointly. Yes,
3 weeks time.
prayer is allowed less after 3 weeks. Yes. You place it.
My lord, item number 24 to 27 and 31, my lord.
24 to 27 and 31. Yes.
My lord. Deep your lordship.
28.
May please, Your Lordship. Your Lordship, I am for the respondent number 6. I'm supposed to file the affidavit in position. Your Lordship, the difficulty is that the respondent is staying there in Peninsula. It was raining heavily, so there was some difficulty to come to Shillong. I'm praying for 1 week.
Yes.
We have filed, my lord, for the state.
You are Mr.
E. Marbanyang.
E. Marbanyang?
Yes.
For 6 pages further, 2 weeks time to file affidavit. Stop. Prayer is allowed. Is allowed for 2 weeks. Yes, after the other respondents are already on board.
29.
Is allowed. Notice that the other are already on board. Yes. Is Mr. Kumar's day doing? Yes.
My lord. My lord, item number 29, we have filed the rejoinder, my lord. So this matter may be posted for hearing and a short date may be given, my lord. This is the matter of maintenance allowance.
Deduction of maintenance from salary. Deduction of maintenance from salary.
Oh, it's a different case.
Yes. Yes, my lord.
Parties submit the appeals are complete on list for hearing on so and so. Yes.
After 2 weeks, my lord, interim may be continuing, my lord.
Interim order is there?
Yes.
Okay, after
yes,
2
my
weeks.
lord.
Interim order, any to continue date.
30.
My lord. Deep your lordship.
In this matter, we have received the affidavit, lordship. Filed by respondent number 3, lordship. We will be filing the rejoinder, lordship.
You are?
For the private party.
Private respondent. I'll be filing in the course of the day, Your Lordship, the affidavit.
You're
I'll be filing within 2 weeks, my lord.
2 weeks?
Yes, my lord.
Yes, Miss. You are newly engaged, madam.
Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship.
Yes, Mr. Who's file? You've got a copy.
You have received advance copy, Lordship.
Yes, Mr. Passing here for 3. Submits that applicant will find the cost of the day. Stop. Mr. SDF 1 and 2 pray for not further 2 weeks time. Yes.
32.
This is also for affidavit, madam. I'm praying for some more time.
What is the matter about MS Hungry?
Lordship, this is with regards to his resignation, Your Lordship. He was not granted.
Why you not like to resign? What is the hurdle?
Lordship, kindly see the improved letter, madam.
Which page is it?
Page 37.
Now we can dispose of here only without affidavit also. Page 36.
37. But he went on deputation to.
Yes.
He went on deputation to Intelligence Bureau, Miller, from 2019 till 24, and even after completion of deputation period, he is not reported to us on reference. And we should.
So he completes deputation in 24.
Yes,
now he's asking for resignation to resign. You want to initiate proceedings against him?
Well, on completion of deputation, he is required because these are discipline process. He is required to come and report and then seek resignation, my lord. What happened from Intelligence Bureau? He went home, my lord. Never reported to us on reference.
Where's his home place?
Your Lordship, it's towards Tawang side, Your Lordship.
Changalang district.
Tawang district.
Is on the
Arunachal.
eastern part.
Yes, Your Lordship. District of Tawang, Your Lordship.
Yes.
Your Lordship, he was not able to come because it's been mentioned because of the sickness of his mother, Your Lordship. She was very ill, that's why. And after that, during the IB also, when he was in IB, he has already filed his resignation, but his formal resignation he gave on 2207.
When he was in IB, where's this copy?
A letter was served, Your Lordship.
Was it considered?
No, Your Lordship. It was they had taken into consideration, told him to go to the parent.
Page?
29, Your Lordship.
Yeah, Dr. Mozika, if when he was deputation also he had
filed one resignation, Your Lordship.
He submitted resignation to IB. IB is not the parent department. He has to submit resignation to Assam Rifles. We will file affidavit. Whatever.
But I think in the after it's necessary. Yes, Dr. Mozika place sponsor for a 2 weeks time to file affidavit. Just the afterwards.
33.
Much a pleasure, Lordship. Lordship, I'm seeking more time, another 2 weeks time.
Why?
Lordship. Lordship, I'm seeking the
Any interim orders operating?
No, Your Lordship.
What's this matter about? It's not interim, so many matters.
Yes, Your Lordship. This is with regard to the stay of transfer of land, alienation of land, Your Lordship.
That's been stayed.
It has been stayed by us, and this court has also reiterated, Your Lordship, by order dated 20th May 2026, Your Lordship.
When will you file affidavit?
Your Lordship, I'm just waiting for the parawise comments. Once I receive those, I'll file.
You're Mr. Marpan's
Yes,
junior
we
colleague.
need some more time, Your Lordship, to file the affidavit.
Who are you? You are representing?
Respondent 5.
Who's this?
He's the original complainant, Your Lordship.
Okay. On the prayer of MSP is now brief 1 to 4
Respondent 5.
and for respondent 5 for the 2 weeks time allowed for affidavits. Yes, please thereafter.
34.
Yes, yes.
Lordship, the respondents are to file the affidavit.
The instruction I have received, my lord, they have been asked to supply certain documents, my lord, which they have not supplied.
You give a copy to her.
Because of this, we are not able to trace the records of the petitioners. One more copy.
Your Lordship, earlier also, Your Lordship, they have raised the same issue, Your Lordship, where in the regimental number, Your Lordship, they are unable to trace, Your Lordship, 2 of the letters.
Then what can we do? How can it be a stalemate like this?
Your Lordship, in fact, under the same regimental number, Your Lordship, my late sister as well as my late mother also has received the family pension, Your Lordship.
Yes, take
We
down.
can facilitate it, they can go and meet the concerned officer.
Just take down Dr. Mozika to produce a communication dated 7 July
Yes, sir.
2026, which indicates that the matter has been held up as the respondents are unable to trace out the database held with the library secretary, and all further they require the petitioner to provide the correct regimental number copy of the PPO book and discharge certificate along the documentary proof. Stop. Next by MS GDC Marbo, when the council petitioner submitted that this issue submits that this is not the first time that this query has been raised, as not understood as to what other information they have to provide in view of the fact that your mother,
My late mother as well as my late sister.
petitioner's late mother and
Late sister, Your
late
Lord.
sister were receipt of family pension.
In fact, the same communication is annexed with the writ petition also, my lord. At page 52. Same thing was told to them earlier. Also.
Received the family pension stop. Dr. Mozika, who suggests that maybe
Or can you send for
if you just go and meet them.
mediation also?
Yes, we resolve if the writ petitioner approaches the respondents. Who's the concerned respondent? Since a pension matter, personally.
OIC legal cell, my lord.
OSD?
Legal cell.
The OSD legal cell. At this headquarters here?
In Shillong.
At DGR headquarters. Where is the petitioner situated? In Shillong only?
Yes, Your Lordship.
Or he's in Nepal?
Lunglei, Mizoram, my lord.
He's in Mizoram? Oh, yes. That will be difficult. I'm nice home to Thoba. Perhaps at home. Personally, however, the Council of Pictures submits that as the picture staining in a remote area in Mizoram, this court, in consideration thereof, directs the respondents to consider the matter on the basis of the earlier family pension granted to the late mother and sister of the petitioner on the materials that were placed at that point of time. Yes. This after 4 weeks for the orders, yes, and for examine it.
35.
Yes. Who's for the petitioner?
Mr. S. Your Lordship.
What's the matter about?
It's a freezing of an account, Your Lordship, SBI account. They were supposed to take steps on the private respondents, Your Lordship.
None appears for the petitioner. This is a matter of 1 week, yes.
Obliged, Your Lordship.
36.
Please, Lordship, we have issue notice regarding to the pro forma respondent.
Yes. Officer indicates that the service on form respondent number 2 is not complete. Yes, petitioner is permitted to obtain status and to file affidavit if necessary. Yes.
Respondent 1, I'll file my affidavit in 2 days' time. In fact, the contesting respondent is only respondent 1, Your Lordship.
Whom is the IQC?
ICC, Your Lordship.
ICC.
Internal Complaint Committee.
This matter, what's happened to this matter?
There's a complaint against me, sexual harassment.
I know that. I mean, what's happened now as on today?
Today, because I have preferred an appeal, Lordship, before the appellate authority. Now, aggrieved by the maintainability order passed by the appellate court, Lordship, they had preferred this instant repetition on the ground that the appeal is not maintainable before the appellate court.
Yeah,
so the contesting party is only respondent 1, Lordship.
So if you file rejoinder, I will take it up for hearing.
No, I'll be filing the affidavit in 2 days' time.
Oh, you want to file it as yet?
I have not filed as yet.
Then you say that. Yes, Mr. Amnapur submits that it will be filed on behalf of one within 2 days. List after 2 weeks for rejoinder of any.
Okay,
yes.
Lordship, there's a stay order in this matter.
Yes, interim order of any to continue till next date.
Will you oblige, Lordship?
Yes.
37.
Yes, Mr. Hansaria.
Please, Your Lordship.
You filed your notes and submit.
Yes, my lord, we have. We have.
Would be taken up at the end of the board, because the learned advocate general is on his legs in another court.
Very well, my lord. End of the board, I have no difficulty, my lord.
Yes, out of some time.
Obliged.
So long as Your Lordship take it up today, my lord.
Of course, I mean, yes. But I think all arguments are more or less complete, only waiting for,
Yes. Written notes.
It's only argument we have submitted also. It's only for the district council to make, my lord, whether regular courts will try or the district council courts will. That's a limited and it's covered by the Supreme Court judgment, my lord. But since Advocate General wants to address Your Lordship, my lord, I'll also be there, my lord. Assist the court, my lord.
Yes.
Okay.
Hearing. Supplementary list. Item number 4.
See, Mr. Longkhaw, it can't go on like this forever.
I understand, Lordship.
Now the matter has been fixed for passing judgment since
2024, Your Lordship. You see, Lordship is like this.
Should we pass orders to direct them to pass a judgment immediately? Settlement doesn't seem to be working also. Then what are you to do then? Even waiting for the order, waiting for the settlement?
My no, Lordship. But see, it's like this. The petitioner at present, they requested the respondent to let them buy a piece of land in which is still being considered by the respondent. As of now, they have not decided anything. So that's why the lower court below has given more time to consider maybe.
Plot of land from where?
Initially, there was a land in Tura which have been purchased by the respondent number 4. Even the petitioner was also the owner at that point of time before the severe tie from the respondent.
Church.
Yes, Lordship. And then thereafter, they still claim ownership over the same plot of land by surreptitiously changing the pata in their name. So the dispute arises after that, Your Lordship. So right now, that's why the respondent has filed that title suit in Tura. But as of now, again, the lower court has fixed time and again for settlement. But this time they have again asked, the petitioner has requested to let them purchase a plot of land in which is still being considered by the respondent, because that is yet to be seen.
See, that matter won't go anywhere, then why they holding back a judgment? Let the judgment be passed.
That's true, Lordship.
Yes, Mr. Nyota.
My only prayer now is only for early disposal of the title suit. That is okay, Lordship. We have no problem. The subject matter here is same only.
See, getting another plot of land is in the air.
That is
when you get it. You can't keep the matter pending.
I know.
You know, indefinitely.
So let a direction be there, Lordship. For
yes, it'll be record now.
If I can point out, my lord, the writ petitioner was aggrieved with the order dated 16/10/2024, my lord.
Yes, agree, because that with the pata, right? But it's not if the main title suit is pending.
Yes,
and pending.
What is the order?
Final judgment.
What was the
yes
order of the CEM? If my lord may kindly produce page 41, my lord, para 4. The last 3 line, my lord.
Yes.
Honor which is the appellant, moreover, as submitted by the parties, title suit is pending, which will finally settle the dispute between the parties, hence directed the parties.
Where are you reading from?
Page 41, the last 3 lines, my lord.
Yes.
The last 3 lines of the order.
Yes.
Honor which is the appellant, moreover, as submitted by the parties, title suit is pending, which will finally settle the dispute between the parties, hence directed the parties to hesitate for their rights accordingly, my lord. Now, the suit is already pending. There is no requirement of interference with this order because they have already gone, my
lord. The only thing is to see, they are waiting also for the judgment. Judgment is ready,
my lord,
and the judgment has been kept pending.
Yes, my lord.
Pronouncement because the party said will come to settlement. Correct,
my lord.
So if we don't come to settlement, let the judgment be passed.
Yes, yes, my lord.
And indefinitely we cannot hold this matter here also.
Yes, my lord. And moreover, what I understand, my lord, I may be open to be corrected by my lord seniors. My lord, this matter has become infectious. In fact, since the matter is already there, the title suit will be decided.
Of course,
this matter.
Whatever title suit that will follow, then your patta will be corrected accordingly.
Yes, yes, yes.
That's all we have.
Yes, yes, yes.
The disposal of Mr. Nongklau?
Yes, better.
Yes, Mr. Nyota.
Yes,
yes. The petitioner before this court is stated to be the founder president of the Seventh-day Adventist Church, Mori Nagar, Tura. which had purchased a plot of land and after obtaining Pata had constructed a church in the year 1987. The original church later on came to be known as Pura Adventist Town Church, and Pata was already renewed in the new name, which however was objected by the respondent number 4.
Yes.
You're respondent number 4.
Yes, sir.
You're the one who broke away.
No, no. Yes, yeah. Yes, sir.
They're the one who broke
They are the one. Oh, sorry. No, 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 Your Lordship. They are the one who.
Okay, you both broke apart.
Yes, sir.
Yes. Objected to by the respondent number 4, which is the Garo section of the Seventh-day Adventist Church, New Tora Aramai. It appears that thereafter proceedings before the GHADC had resulted in the Imperial Order dated 16/10/2024, wherein the respondent number 4 had filed an appeal against an order dated 23/3/2018 passed by the Assistant Settlement Officer.
Against the other 13, Your Lordship. 1310.
1310, no.
Yes, Your Lordship.
Appeal is filed by them.
Yes, against that the other 13/10/2022.
22 or 18?
22.
See, come to the Imperial Order, Annexation 9. Oh yes, okay. Oh, so yes. Appeal against against the order dated 13/10/22, who dismissed the appeal, the appellant against the Assistant Settlement Officer's order on the ground invitation. So, it is noted in the Imperial Order that, as per the records, land Pata, the name of the appellant, that is bracket respondent number 4, had been cancelled without due notice, and the absence of the notice. And however, since the main matter was pending in a title suit, the parties were directed to await the outcome and to agitate their rights therein. Correct? Yes. Next paragraph. The parties jointly submit today that though through several dates, the trial court, right? Trial court, with the title suits pending, has fixed matter for judgment, but in view of settlement talks, the matter has been kept pending. So today they submit that as it appears that the settlement will take some time, perhaps the judgment and order and title suit be pronounced to enable the party to take further necessary steps, as would take any further necessary steps in the matter. Stop. Mr. SD, parties meet Mr. So for you and for Mr. SD appearing for the official respondents, GCDC, has also submitted that, has also supported the submissions made by the parties, and submits that since the matter, so the main matter is pending in title suit and judgment has been is yet to be pronounced, the matter can be closed by perhaps issuing a direction that the judgment pronounced, that the judgment be declared or be pronounced, so that the parties can take their case forward. This court, on hearing the land counsel of the parties, also examines the records. Notes that, where's the order sheet? Notes that since 25 has been fixed, 7/8/25.
Since 24 December 24 years.
Where's that, the first one? Yes. Notes that this court has recorded that the matter that stood pending before the Court of Assistant Deputy Commissioner West Castle Tura has been posted for judgment as far back as December 24 and had been refixed from time to time through the year 25 due to the fact that the settlement was being worked upon. However, on assumption, however, as is noted, as is seen that the settlement is to take some time, the trial court perhaps sometime the circumstance of the case, it will be more expedient perhaps if the judgment has been reserved for pronouncement, which has been reserved be pronounced. Yes, and the parties have to take further steps as necessary in conflict law. Matter stands close.
All right.
It will not go anywhere.
49.
Which order was passed 53?
Lordship.
Which order was passed on WC 53?
Lordship, that is judgment and order dated 17/12/2012. Lordship, today I prepared the
In the earlier matter, he had come. How many petitioners? He had come.
Only one petition. I was only alone.
What do you mean common judgment order dated 17/12?
Common judgment because there are two writ petition, 53 and 54. So that's why common judgment. A different pair was there.
One matter totally. When was the last heard? Was it heard, this matter? No.
No, Lordship.
Yes. Let him start. You ready?
Yes, start, but I'm not able to understand anything.
I can't understand this note. You only to show the court.
Lordship.
See, what are your only this is a court. What is your
grievances?
Your entitlements. Correct.
It's very short, Lordship. Very short. My grievances is that I was not given consequential benefits. That is, I was supposed to be promoted to the rank of senior accounts officer. After they have promoted me to the rank of junior accounts officer. So accounts officer. Then they have promoted me 1/1/2011 accounts officer, and I was supposed to be promoted to the post of senior accounts officer with effect from 1/1/2013. That is my prayer, Lordship. This is a basic prayer. Apart from other prayer is there for fixation of proper pay scale, Lordship. Because, Lordship, the judgment and order dated, that is 17/12/2012, is saying that consequential benefits should be given to
Where is that? See?
Lordship, that is page Annexure B, page 34 is the judgment. Operative part is Annexure B, page 34. Operative part is at page 45. That is the last paragraph. Page 45. That is para number 6. The last
Para
line,
5, para 6.
Para 6, Lordship, last line, the last line, page 45, the last line, with consequential benefits, Lordship.
Where? That's in
Page 45.
44.
Page 45, para 6, Lordship. The offshoot of
There are two para 6. 43 also is on para 6.
No, Lordship. Page 45.
Yes. Page 43 is on para 6.
Lordship, yes, Lordship, but.
And page 45 is not a para 6.
This is a typographical mistake from the
Yes.
certified copy itself. But it is page 45, para 6.
There are 3 para 6.
Yes, Lordship. There are 3 para 6.
How is it possible?
That is
page 43 on para 6, page 44 one not para 6. Which one? The right one is page 45.
How will Lordship, the operative part is page 45. Page 45. The last paragraph.
Yes. The consequence.
The offshoot of the following discussion.
Has these rules been amended, Dr. Mozika? See, it talks about a merger of the post of senior accounts officer and post of accounts officer.
Lordship, it is not merger of senior accounts officer, it is the merger of senior accountant, junior.
Oh, sorry, senior accountant with post of
junior
accounts officer, junior accounts officer. Record of this. You want to amend.
Or may I pray one thing? I'll call the officer because I'm also not able to understand. But date is fixed and Mr. Dev is here.
You're supposed to give a small chart showing entitlements as per the orders. Whatever you've given is, you can't make out. It's more confusing than your petition.
So I'll try to file a simplify.
Not simplified now. The thing is that now, offshoot point discussion, the board is allowed. The responsible authority is directed to amend. Can the court direct to amend the rules?
Lordship, as per the office memorandum issued by the government of India.
You have to amend.
Yes, Lordship.
Has been done.
Yes, Lordship.
When was it done?
Everything was discussed.
When was it done?
Lordship, it was not done. As per my.
It was not done.
Yes, Lordship.
Till
As per my instruction, it was not done, Lordship.
Till now, still not done.
Yes, Lordship. As per my instruction, Lordship.
It has been done till now.
Yes, Lordship. As per
Then
my
how do you
instruction.
get the entitlements then?
Lordship, that is what, Lordship,
So
they have
the
merged.
post that will be entitled to senior accountant scale, then you won't get it now if the rules have not been amended. And then thereafter to consider review DPC.
But by page 34 by an office order, he has been granted all the benefits. Page 34 of the affidavit.
That is, Lordship, I am disputing. That is what I am saying, that I should have been.
Affidavit.
Page 34 of the affidavit.
What remains now?
Lordship, my only grievances is that after promotion to the post of junior accounts officer, I should be promoted to the post of senior accounts officer.
Those posts have merged now.
No, that senior accounts officer is not
accounts
merged.
officer, senior accountant has merged.
Yes, Lordship.
And then junior accounts officer, record officer is what has merged.
Merged, Lordship.
So you are junior accounts officer.
Yes, Lordship. I've been appointed as junior accounts officer with effect from 1/1/2009. Then thereafter I was promoted to senior account officer. Lordship, no, Lordship, account officer. Then now I'm due for promotion to the post of senior accounts officer with effect from 2013.
Senior accountant is not different from senior account officer.
No, Lordship. This is a junior post. This is a low.
Senior accountant is junior post also.
Lordship.
So senior accountant, very confusing. And accounts officer is merged now. One is the same post.
Lordship.
And junior accounts officer, record officer. So you're junior, you're appointed to senior accounts officer.
Yes. Now I'm entitled for promotion to the post of senior accounts officer.
Okay. DPC has not been convened.
No, Lordship. For the post of senior accounts officer, they have just promoted me to the post of accounts officer.
When have you retired?
I've retired in the year 2021 in the post of senior accountant.
It's
only financial benefits now.
Only some retrospective financial benefits.
Lordship, that is because, Lordship, I have been promoted also with retrospective effect, because I was promoted with effect from 4/7/2024, I was appointed with retrospective effect on 1/1/2011. So that is the respondent.
So you got your arrears for the 24 to 11.
Lordship, that is what Lordship they have made. The respondent has made erroneous calculation in the pay statement also.
From
that
11 to 24.
Lordship, no, from Lordship 2006 till date, Lordship.
2006 till date.
Yes, Lordship.
So by your chart, if you had made it, what would be the arrear totally you have to get?
Lordship, I have stated in my petition.
How much?
That is, Lordship, from 2006, I was entitled to get a pay scale of 6,500.
Different 50 rupees something, no?
Yes.
50 rupees.
6,000, Lordship, I have stated. Kindly come to page 49, Lordship. That is, they have erroneously fixed my pay scale. That is, Lordship, page 49.
Oh, you said it should be 6,500.
Yes, Lordship.
6,500. 5,300.
Yes, Lordship.
So difference is?
Difference is 1,200, Lordship.
So you have to get arrears from 2006.
Lordship.
Till you served the post of junior accounts of 2006 onwards.
Lordship.
Then the post was merged.
Lordship.
Then you went to higher scale.
Lordship.
Or you remain the same.
Lordship, Lordship, at present, Lordship, pay scale is not.
Because it becomes very difficult then if you claim 2006.
Lordship.
That's why I think the last time we said make a small chart. You know your entitlements and what be total amount by your calculation.
I'll simply.
Will come to crores.
I'll just file a simple.
Just be clear, about what's the time you claim. You see that you've been promoted, and the thing is that they have not calculated it correctly.
Lordship.
See, the thing is that you were promoted as a junior accounts officer.
Lordship.
No, accounts officer from which year?
From 2011. Accounts officer, 2011.
Then the senior accounts?
Now I am due for promotion to the post of senior account
officer. You can't claim this scale. This scale 6,553. That's very confusing. Anyway. Now this calculation is.
Lordship, I have prepared.
Who made this annexure E?
Lordship, kindly come to my
annexure E. Who made this annexure
kindly
E?
come to my rejoinder affidavit.
1 second. Annexure E 49. Who made this one? This is from the. They say 5300.
Lordship, my apology, Lordship. Which annexure?
Page 49. The one you're reading just now.
Page 49. Okay. Yes, Lordship.
This is prepared by.
Prepared by some lieutenant commandant, some commandant of Assam Rifles.
So you disputed this that time?
Yes, Lordship. Sorry?
Did you dispute this in 2020?
Yes, Lordship. I'm disputing. And it was prepared in the year 2000.
Samir Chandrakar, SC Karan, his signature is there, my lord. Page 50, Lordship, kindly see, my lord. Prepared by so and so, checked by himself, my lord.
Senior accountant.
Senior accountant.
How can an accountant make such mistake? You can understand any ordinary Jawan making mistake.
Actually, Lordship, they have prepared this pay statement, the post of senior accountant is also no more, as per the direction of this honorable court. But they have given me this pay scale in the post of senior accountant.
So it was merged, it became just accounts officer.
Lordship. No, Lordship. After merge, it becomes junior accounts officer. Now.
1 second. What is accounts officer? Not junior accounts officer. This is the designation senior account.
Lordship.
See,
Lordship.
It's very confusing. Yes.
Lordship, I prepared a chart. Lordship, kindly come to my rejoinder affidavit. Lordship. For entitlement, I have prepared a chart that is rejoinder affidavit, page 5. Lordship.
Page 5.
Page 5. The pay scale and the grade pay, Lordship.
So the chart will not answer it. Just showing as per fifth pay commission how much you have to get.
So Lordship, I am entitled for those pay scale, Lordship. So Lordship, when they have prepared the pay statement. So I was entitled to get the pay, that is pay scale of 6,500, Lordship. But they have given me 5,300.
And you signed here also?
Lordship.
Why do you sign it then?
Yes, Lordship. Lordship,
Why do you sign it here? Checked by SCCA senior accountants, checked by you only.
Lordship,
prepared by Havaldar something and checked by you. And it's signed by the dignity, by the head office, yes.
Probably, Lordship, I will take instruction, but it appears that I was, Lordship.
After you checked it, then the head office signed it, and your own fixation of pay statement.
Lordship, probably it seems, Lordship, I was performing my official duty. So, Lordship, I was just, because it was prepared by someone else, then, Lordship, I was just signed.
So I mean, Lordship, it concerned you only.
Lordship, so for that, Lordship, I'll just take instruction.
So, what put up, you signed.
I understand, Lordship. Lordship, I'll just take instruction that why it is like this.
How can we official? That means it's official duty, you don't care what you do. When it comes to
Lordship, I'll just take instruction regarding this signature, Lordship. I have not checked it.
I don't understand. How will we dispose of this matter? And you already relinquish your right by official documents only.
Lordship, that's true.
Didn't see till just now. First time we've seen, I think.
Lordship, yes, Lordship.
Yes, the statement of pay fixation, which is disputed by the petitioner on the ground that the basic pay recorded therein is incorrect. As instead of showing 6,500, it is rupees 5,300 is shown. Stop. Dr. Mosika, that judge, I hope, has drawn attention of this court to the fact that the fixation of pay statement, which is contested by the petitioner, was checked and signed by he himself as a senior accountant, and thereafter was approved by the head office. Submitter submits that the pay statement having been checked and made by the petitioner, at this stage he will not be in a position to challenge the same. Mr. BTEP on this submission prays that he be able to obtain instructions from the petitioner. You ask him, or we'll call him here in court. So official duty he just signed blindly.
It's I will just take instructions.
Okay. Just after 2 weeks.
2 weeks.
61.
Maybe please your lordship. This case earlier also, similar case was filed, took part in the interview, then challenged the interview later. So in the earlier case, your lordship has dismissed the petition. That was the
yes, because the wrong nomenclature was shown, correct?
There's a doctor in the slow medical call.
Wrong nomenclature, or is it a different case?
With regard to nomenclature, it was there, but the petitioner, none of them were having a certificate, that certificate. So the same ground, again, another petitioner has taken. And our one...
Where's the petitioner?
Petitioner absent. Earlier also it was absent, your lordship. Then your lordship, in fact, earlier supposed to dismiss, so they may not be interested, I think. Because the result record...
Last was rejoined after it will be filed. 2 weeks time was rejoined after. They filed 17-6. None appear to have the petitioner. Yes.
Behalf of the petitioner, Your Lordship, the present petition is different from the one which was filed before, in that petition, the final order in that petition did not address the issues of ineligibility and discrepancies in the selection process, which the petitioner has argued were deliberately conducted so as to lead to the arbitrary appointment of respondent number 6. Your Lordship, if you will see, Your Lordship, the minimum eligibility criteria.
1 second.
In the
Where's the advertisement?
Your Lordship, at annexure number 2.
Yes.
Your Lordship, if you will see on page number 2 of this annexure, Your Lordship, the post in question is that of associate.
What's the post in question?
Your Lordship,
that
associate professor.
Page 2 of the advertisement. This is?
Yes, Your Lordship. This is the eligibility criteria, table 1.3. And if you will see, Your Lordship, the first row pertains to the associate professor and the fourth column is eligibility criteria.
Yes.
In this, Your Lordship, if you will see at entry number D and E, the eligibility criteria prescribes 2 certificates, which are abbreviated to CBME certificate and BCBR certificate. And these are mandated by the National Medical Council, Your Lordship, for such appointments.
This assistant professor.
Associate professor.
In which branch? Dentistry.
Your Lordship, dentistry.
Okay.
The respondent number 6, Your Lordship,
yes,
has admitted in her rejoinder that she does not possess the CBME certificate, and moreover she has obtained the BCBR certificate, but that was obtained after the present petition had been filed. Now, Your Lordship, interestingly, both counter affidavits do not actually produce the documents pertaining to the private respondent's selection.
Who the private respondent? You are appearing.
Yes.
Okay. Yes. Yes.
Your Lordship, the documents such as the application form, which had to be filled in by a prospective candidate as per annexure 1 of the same advertisement, that specifically asks whether the candidate possesses these 2 certificates or not, and it's entered as a yes or no question, Your Lordship. In fact, Your Lordship, the advertisement goes on to state that if there is any suppression in the application form, any suppression of information, then the candidature is liable to be terminated.
Yes.
However, Your Lordship, this application form has not been adduced by either respondent, and therefore, Your Lordship, my prayer before Your Lordship today is that all the records that pertain to the private respondent's selection.
There was no formal publication of results. There was no publication of results for this post. Were the results published or not?
Yes, published.
It was published, Your Lordship.
However, and did the
that
petitioner's name figure in the select list also, number 2, number 3? There was only one name.
Yes, sir.
There was
no,
one. Okay, yes. Please continue. Yes. Yes. What is the submission? What is the records? Yes.
Yes, Your Lordship. My apologies, Your Lordship. I believed you were addressing to me. I'm sorry to interrupt.
Yes. No. Yes.
Yes, Your Lordship. The result was declared in March. My submissions are that in January of 2025, before the result was declared, the petitioner was regularly following up with the department as to when the result will be declared. However, he was never given a clear response, and finally, when he got in conversation with an employee of the Shillong Medical College, he got to know that the post has already been occupied by a person. And in that regard, Your Lordship, the petitioner has adduced annexure number 4, which is a document issued by the state respondent, Your Lordship. However, the state respondent has denied it. This document is relevant, Your Lordship.
Which page is it?
Your Lordship,
89. Yes.
Yes, Your Lordship. This is relevant, Your Lordship, as at column number 10 date of joining. It states that the private respondent has actually joined the college in January and has been drawing salary since then. However, the result was declared in March.
Where I want to see where the declaration of results. That's what the court asking. Where the declaration of results was it ever declared at all?
Lord. It was declared, Your Lordship.
Where is that?
Your Lordship, that is.
You are prepared for the matter. Yes. Annexure?
Annexure number 7.
This is 18th March. Okay.
Yes, Your Lordship. And at
then she was there from 20 January in what capacity? Provisionally selected.
Your Lordship, all selections as per the advertisement had to be provisional.
Yes.
However, she was appointed provisionally even before the result was declared. Now, Your Lordship, the controversy as far as the date of joining is concerned is not settled because the petitioner is relying on a document which the respondent has denied issuing. So therefore, Your Lordship, what the petitioner prays for is that all the records as far as the private respondent's selection are concerned, they may be produced before this honorable court so that arguments can be extended on that solid foundation.
But we'll find the result, my lord, in our affidavit in opposition, annexure 1, which is at page 60.
Your respondent number 2. Affidavit respondent number 2.
Yes. Respondent number 2. The result. This is annexure 1, page 60.
Page 16.
Page 16, my lord, annexure 1.
Once again.
Your Lordship, I'm unable to hear my learned senior. If he could come closer to the microphone.
Yes. Is this the result? This they dated November 1824.
Yes, my lord. This is the result. Marks for interview and subsequent page, my lord.
This is the annexure 1, page 16 of the affidavit of respondent number 2. Is this the result? Because this is dated 18 November 2024. Yes.
No, Your Lordship, this is also dated 18th March 2025, annexure 2.
No, annexure 1 of the
and my lord, subsequently, my lord will find it annexure 2, page 17, which is the notice.
18th March was the same thing.
Yes.
Yes, Your Lordship.
No, what about November 1824?
My lord, here my lord will kindly see the marks which have been allotted to the candidates.
It's a walk-in interview.
Yes.
Now, where's the respondent?
Number 4. My lord, respondent is number 4.
And the petitioner?
Petitioner is number 2. And marks out of 40.
Number 2.
Yes, my lord.
Amit Danish.
Yes.
5. And the other one's got 20.
Yes.
Yes.
Your Lordship, the petitioner's contention is that since the whole selection procedure was based on a bias from the get-go, therefore, the marks which emanate from such a biased procedure cannot be relied on to make any inference as far as the petitioner's merit is concerned.
But you took part in the selection, then you should have objected to the process adopted.
Exactly. Your Lordship, I participated in the
Yes.
selection procedure, but the bias became evident to me only after the procedure was finished. When I appeared for the personal interview, possessing all the necessary certificates, I knew that it is standard procedure that during the interview, all the documents are verified. Therefore, I approached the authority that, look, I have my documents. Can you verify my eligibility? As a careful candidate, I took this initiative, and I was told that the documents will be verified at a later date, which date never came. And thereafter, Your Lordship, I got to know that the private respondent, despite
Didn't
not
have these two
possessing-
certificates. That's CBME and BCBR. Yes, were the this is a mandatory requirement as per the advertisement. It seems that these two certificates are mandatory. It's a should.
None of the candidates had the certificate. So
Even the
later-
petitioners
Your
don't
Lordship,
have
I had
these.
them.
None of them had the certificate, but later on I possess, Your Lordship. That is, I have given in my affidavit in opposition. I got 72%, Your Lordship.
No. With regard to these two certificates, you possess them.
No, that time none
Then
of
that
the
means none of the candidates are
none of the
qualified.
candidate possess.
Then how does selection go
Your
ahead?
Lordship, I possessed it. I have put it in the petition.
So I possess. I got it 72%.
No. Forget about the marks, Mantha. Now see the advertisement, as we saw earlier, requires two certificate courses. Like you should have two certificates, which
But
the
to my
CBME and BCBR.
information, Your Lordship, none of the candidates had a certificate.
Then we'll call for the records. Are all the testimonials filed during the time of application
Yes.
are still in the custody of the what respondents? This is
Respond number 2. I may be allowed to seek instructions for the first instance.
because that point is, see, the one thing is
Because
the
otherwise-
one thing is the walk-in interview, right? And then the walk-in interview, that means walk-in interview. Yes, that means that at least the testimonials should have been examined, and it should have been a sort of
There's a specific statement by us that everything, all the credentials has been examined.
no, statement is fine, but then whether there's any what do you call it, objective assessment of all the as per the criteria. Whether all the candidates, whether it's candidate who's appointed in challenge fulfills the criteria.
If I'm allowed
We can't have kind of just a selection like that.
if-
Walk-in interview, you can give any kind of marks, but at least the basic baseline should be satisfied.
My lord, if I'm kindly allowed to read para
Otherwise,
A.
we'll call for the records. We'll see right from
in that event, my lord, will kindly allow me
from
to seek
point A
instructions.
with regard to whether there's any objective assessment before. Now, walk-in interview, that means that you have to present testimonials there, or it was submitted earlier during the application.
Submitted earlier with the application.
Then
My lord,
that gives you more time to check.
My lord, if I'm allowed to kindly read para 8 onward, so it will be a little clear, my lord.
8 of?
8 of my affidavit, my lord.
Read it. What does it say?
Page 3. Bottom, my lord. That in response to the averments made in para 5, 6 and 7 of the writ petition, the answering deponent, while denying the allegations of the petitioner as false and baseless, states that all applications and the supporting documents of the candidates underwent rigorous scrutiny. The documentation was examined by the senior most dental surgeon of Health and Family Welfare Department, Government of Meghalaya. The examiners were specifically tasked with verifying the credentials of the
It's all well and good, but where's the
teachers' eligibility, qualifications, etc., my lord.
You see the records, then if she doesn't have certificates, then she doesn't meet the basic criteria.
As far as the letter dated,
So your whole selection is, yes, in the course of
my
hearing.
lord, in that case, my lord will kindly allow me to seek instructions.
You produce the records, you'll save you a problem of getting instructions.
At least one opportunity, my lord.
For
seeking instructions. Thereafter, if required, we will produce one of them.
what instructions you'll seek now? Is at the hearing stage, only that this court has just seen that maybe there might be something, at least the thing is we put to rest. One thing is that he's subjective to selection, that's well and good, but the thing is that if they do not possess the basic criteria which has been prescribed.
Only with regard to that, my lord. Whether
you put it to the
anything is
records, yes. In the course of hearing, it appears that the entire records pertaining to the selection to the post of associate professor dentist in the Shillong Medical College are necessary for proper adjudication of the matter. Stop Mr. K.B. Vrasari appearing for respondent number 2 who will receive the record directed to produce them on the next date. You take a date then, based on so and so. It's just for the court satisfaction. Yes.
Grateful, Your Lordship.
Yes. Where's Mr. D? He was here
He's
earlier.
coming, Your Lordship.
So this is a case where this an extra one.
Have you served the private respondent? The successful bidder.
Yes, successful bidder. The one, because I taken a ground that by manipulation, they manipulated the amount. They showed me the highest bidder, and that is the ground for rejection. By filing the affidavit, they have not denied. They did not say anything about the manipulations. So this is
they manipulated.
They manipulated, but did not utter even a single word also. How it was manipulated, who had done it.
You think they'll see how they manipulated it?
But they have not said. No, at least responsibility may be fixed to somebody else who might have done. But in this case, it's very silent. So that was my case only. That I was a lowest bidders, but by showing that
Highest bidder.
I was a highest bidder. This one.
Page 20.
Page 20, Lordship. And the another one is.
There's a market. No?
Is a
market.
Is a market, yes.
Paragraph. What are you referring to?
Page 20.
Or page 20?
Column 3. Column 3, yes. This is the manipulation. This is the manipulation only. Because I was the highest bidder. The amount which I offered is.
Sibat Marak.
Sibat Marak.
This where
That Dadingiri market, if my lord may kindly see serial number.
Dadingiri market, yes.
Dadingiri market, number 2 is the name, serial number 2 is the name of the petitioner. 12 lakh 11,020.
And the amount which I quoted is a 14 lakhs 50,000. And here
the Dadingiri market shown as you quoted 12 lakhs 11,000.
Yes, but my amount which I quoted is a 14 lakh 50,000.
For that, my lord, what I suggest, my lord, let the record be called, my lord, whether there was any manipulation or not, my lord.
Manipulation on.
Yes, apparent admitted facts. They have not said anything. This is the only ground.
So you tendered the amount of 14 lakhs.
14 lakhs.
But they've shown it as 12 lakhs.
As 12 lakhs.
How is this possible?
This already, sir.
Where's your bid amount?
By bid amount is page
17A.
Page 17 is the
type copy is the page 17A.
Type copy is page 17A. Column 6. What's it? Para 5.
Yes.
It's a 14 lakhs.
What does Apple say about this?
They have not said anything. Everybody, they have not said anything. No explanations at all.
That is why, my lord, record will be required, my lord. How it has.
We'll allow repetition.
How it is done, my lord? Because my affidavit, if my lord may kindly see the affidavit that we have filed. My lord may kindly see.
What's that said?
Even if you exercise the discretion, what are the reasons for not allotting, not giving to him? And why? The thing is that you have to explain is how on the chart issuing the amount bid by the petitioner to be low.
Exactly. My lord may kindly come. My lord may kindly come to page 5 of my affidavit.
Yes.
Para 5.
That in reply to the contention of the environment made in writ petition from para.
What's the harm due to him? Even if you see it in excess of the amount that's feasible, give it to him. You have to
No, but
cover that money.
We are not bound to pay to the highest or to give it to the highest bidder, my lord. The regulation allow us, my lord, that we can give it to the second highest bidder, taking into consideration the last market value, my lord.
Where have you said that?
That is why, my lord, it is not correct.
Not said.
Can I submit?
Just submit.
Very unhealthy practice.
See. Don't get personal here.
No, but my lord, he's keep on uttering the word when I'm trying to put something. What I'm saying is this, my lord. If my lord may kindly see the market regulation, my lord.
No. See one thing.
Market regulation
if you're saying that there are other factors that that prevented or that made you decide to settle the market with the second highest bidder because of the revenue generated from past year with the material and affidavit to show. Yes, you have the discretion. But how you exercise the discretion? That's what the court to see.
That is why, my lord, in a comparative statement, definitely they will write, my lord, why it has not been given to the highest bidder. That is why, my lord, the entire file will be required, my lord. That is why I have made, my lord, what if
you are in custody of the file, you should have reflected that in affidavit. That these are the considerations that made the settling authority, settle the market with the number 2 bidder, not the 1. 1, 2, 3, 4 points. That's it.
But my lord, here, if the claim of the petitioner is correct, that he has bidden 14 lakhs, and the second highest bidder was given the tender, then my lord, definitely the person who has allotted the tender, my lord, he has to give a justification reason why it has not been.
Where's the reason?
They have not stated in the affidavit anything, my lord.
You made the affidavit, Mr. Day.
My lord, on the basis of the instruction that we received, my lord.
That means as a counsel, you have to tell them this
my
is
lord.
the
That is why I am saying, my lord, let it come up next week.
You file additional affidavit within 1 week.
My lord, I will file it, my lord.
Yes, as the replies mean affidavit, especially para 5 or para 9, para 9 is vague and does not disclose the reasons for settling the market with the respondent number
3, my lord.
3. So Mr. S.D. Praise have allowed to file a detailed affidavit and record the proceedings of settlement and the considerations.
But that is one of the ground, but here
doesn't matter.
It is a clear on the face of records shows that is a manipulations.
See, suppose you are just quoting a predatory price, then what will happen? Next time we'll quote 30 lakhs. Then
if that being the case, there will be different case.
Like how much the market can generate.
Yes.
They go by the past revenue generation, right? Suppose you come and put some artificial amount. That means just because you're the highest bidder, they'll give it to you. No, but then you will not pay them. Then as it is, they are already.
First, the regulation says this, but
10 days.
Let after 10 days. Yes.
Second call 37.
Yes, Ms. Ansar. Advocate General is present physically or virtually? Oh, virtually. Yes, please start. Yes.
In fact, the hearing has been concluded in 2004.
Yes. Yes. Because the matter went to the Supreme Court, I think. And so everything was kept in cold storage.
But on 24th September 2004, hearing concluded in some clarification.
Then it went up to the normal Supreme Court. That is why the whole matter
some clarifications
was on a back burner. Yes.
Right. No, it's not required. In fact, if I can just point out to your lordship, the only question which your lordships are considering is whether the regular court or the district council courts will try cases, my lord, in batch of cases. Now there are 3 undisputed facts. 1, all the parties in this case are scheduled tribes from the same area.
Yes.
Undisputed. Second, district council courts have been constituted under the 1953 rules, my lord, framed by the governor under the 6th schedule. Second, undisputed. Third is the district council courts have been conferred jurisdiction by the governor in exercise of power under paragraph 5 by various notifications from time to time, before the CRPC was made applicable and even after the CRPC was made applicable. Now, I fail to understand what so far the first case is concerned. It is of 2019. I don't know how the regular courts have been trying. There was no CRPC. The law is very clear. Your lordships court have been, before the Supreme Court in Melvin case has laid down, your lordships have repeatedly laid down that where both the parties are scheduled tribe, the victim and the accused, it has to be tried by the district council court once the power is conferred by the governor by notification. Now here the notifications are there. Now only thing, my lord, which my learned friend is perhaps the Melvin case in the Supreme Court. I have the compilation of judgments. I'll show to your lordship. I just summarizing what is my submission is. The Melvin case in the Supreme Court 2020 in categorical terms says that where both the parties, that is the victim and the accused, are scheduled tribe, district council courts alone will try the cases, my lord. There is no question of regular courts trying the cases. Now the question is whether the CRPC making applicable in 2022 and BNSS in 2024 has made any difference. Now, my lord, in Commission, this court division bench took a view that in view of CRPC being made applicable, in view of some notification which does not take into account notification conferring on the district council courts, the regular courts will do it. But by detailed order, the Supreme Court had stayed it, that part of the order. So there is nothing remains, my lord, today for the state to say that the regular court still will conduct trial where both the parties are scheduled tribes.
You mean, Mr. Ansar, there is no more scope for interpretation of para 5?
That's right. Now, my lord, let me tell what is the interpretation of para 5, my lord. Yes. I have, my lord, prepared two compilations, my lord. One of the relevant statutes and one of the relevant judgments, my lord. May I just pass it on to your lordship, my lord? And I have given the copies to the parties, my lord. And it is all compilation of the statutes and the compilation.
That's the only question.
I'm so sorry.
Yes. Para 5.
Yes, my lord.
Yes.
My lord, just may I hand over this, my lord?
Yes.
Everything is here. The case law also you given? First, I would like to go to the statutes, my lord, and thereafter to the relevant judgments. But I have the liberty to take first copy from my book, my lord, because all the notifications are here, my lord. I have given taken out from the relevant notifications from there. Would your lordship first see, my lord, page 47 of this compilation, which are 1937 rules. Page 47 of the compilation of my book, Lord, page 47.
Yes.
Which is 1937 rules. And rule 1 says it extends to Khasi and Jayanta Hills. 1A is important. The governor may, if he thinks fit, appoint additional deputy commissioners, either generally for the trial of a particular case, civil or criminal, and may direct such additional deputy commissioners shall, for the special or general purposes, exercise all the powers of deputy commissioner. Then your lordship may kindly come to, my lord, rule 16, criminal justice.
Yes.
Now these rules are still applicable, my lord. This has not been repealed. So far as non-scheduled tribes are concerned. So far as scheduled tribes are concerned, this has been repealed by 53 rules. I'll come to that. Rule 16 says, my lord, criminal justice shall ordinarily be administered by the deputy commissioner, his assistants, by Sardar, Dolois, and chief village chief authorities of the different communities. 17 is important. Deputy commissioner shall be competent to pass sentence of death, transportation or imprisonment up to the maximum amount provided for the offence, whipping, etc., etc., provided all death sentence or 7 years shall require confirmation from the High Court. The second provides that the High Court or the Deputy Commissioner may call for the record of any so-and-so past shall be punished by the sentence of execution. An assistant to Deputy Commissioner shall exercise such powers not exceeding those of magistrate of first class as defined in CRPC as may be invested from time to time. Then your lordship may kindly come to rule 23, which is page 52, which says, my lord, the procedure of the High Court or Deputy Commissioner or Assistant shall be the spirit of CRPC so far as applicable to the circumstances of the district and consistent with the rules. So spirit of CRPC applies, my lord, CRPC does not apply. Then comes, my lord, the 1953 rules. 1950, my lord, page 88. Khasi CMC's order.
Yes.
Because 37 rules did not apply to the Khasi states which merged with the district, United Khasi and Halsa district. And so this CMC order is issued. And rule 1, this order may be called Khasi CMC, come into force at 1. It extends to the area of United Khasi and Jayanta Hills which are known as Khasi state immediately before the commencement of the constitution, excluding such area of the district council which are known as Khasi CNC. Now para 4, my lord.
Yes.
The deputy commissioner or the additional deputy commissioner pass any sentence authorized under the IPC or any other law for time being in force in Khasi state, but any sentence of death or shall be subject to confirmation by the High Court and the court of assistant to deputy commissioner not exceeding magistrate. So two categories, my lord. Deputy commissioner, any sentence, and assistant to deputy commissioner, my lord, of the magisterial powers. Now here also, my lord, lordship may kindly see rule 14. Say the spirit of CRPC is applicable.
Yes.
Shall be spirit of CRPC is applicable. Civil justice we are not concerned with, my lord. We are not. I'm not addressing your lordship, but the similar provisions are there. Now the most important rules are also of 1953, which are at page 97. And these rules are framed under the authority of the Constitution directly. Paragraph 4 permit the governor to frame rules. These rules can be called Khasi Dantiyal District 1953 rules. This may be so and so, so and so. So lordship may kindly come to rule 4. There shall be 3 class of courts as specified below in the area within the Khasi Hills district. So to be constituted by the district council for trial of suits and cases between the parties, all of whom belong to the scheduled tribe, all of whom belong to the scheduled tribe, or other suits or cases between the provisions other than the suits or cases under paragraph 1, paragraph 5, subparagraph 1 or paragraph 5 of the 6th schedule, village court, subordinate court, and district council courts. And what are the jurisdiction, my lord, of the subordinate district council courts is given in para 7, rule 7, my lord, page 101. And rule 9 says, my lord, there shall be one district council court which shall be called Khasi Hills District Council Court. There shall be consist of one or more judicial officers to be designated as judge appointed by the executive committee with the approval of the governor. Now, what will be the jurisdiction of the subordinate district council courts, etc., are given, Lord? Not necessary. Lordship may straight away come to rule 43. That is very important, my lord. Then I will go back to rule para 4 and 5 thereafter. Now, 43.
Yes.
In criminal cases, the procedure of the subordinate district council court and the district council court shall be the spirit of CRPC so far as applicable to the circumstances of the case, not inconsistent with the rule, chief exception, etc. And rule 58, repeal and saving, at page 119.
Yes.
The provisions of the Khasi States Administrative Order 1950 rules published by these on so and so, and the rule for administrative justice in 1937, and the Assam District Autonomous District Regulation 52 published by the government of Assam dated so and so are hereby repealed so far as they relate to matters dealt with in these rules. Now these rules deal with cases where both the parties are scheduled tribes. So 37 rules are repealed by this. Now would your lordship come back to my lord? Sorry? Para 2 also, may I read that, my lord? Notwithstanding such repeal, every suit, appeal, application, revision, proceeding, other business, so and so, criminal pending before the date of the roll, before the deputy commissioner, additional deputy commissioner, shall be transferred or deemed to have been transferred for disposal of court, would be competent to try and dispose of the suit, appeal, etc. under these rules. So, my lord, even pending cases are being transferred. Now, would your lordship come back, my lord, to paragraph 4 and 5, which are there in this compilation at page 1, which is paragraph 4 of the 6th schedule. The regional council for an autonomous, sorry, my lords have got it.
Yes, yes.
Yes. The regional council for an autonomous region in respect of the area of such region, and the district council for autonomous district in respect of the area of the district other than those where the district regional council, if any, within the district now may constitute village council or courts for trial of suits or cases between the parties, all of whom belong to scheduled tribes within such areas. Now, exception is other than suits.
I don't think there is any.
My lord, to the exclusion of so and so. Very well, lordship knows my lord much better than me, my lord. So now lordship may kindly come to paragraph 5,
yes, paragraph 5,
which is page 3 of this compilation. Conferment of powers of CPC on certain courts. Now what? For trial of certain suits, cases and offences.
Yes.
The governor may, for trial of suits or cases arising out of any law for in commencement of court, or for trial of offences punishable with that imprisonment for life, for a term not less than 5 years under the IPC or under any other law for timing application. Now what does this do? Confer the district council or the regional council having authority over such district or region or on courts constituted by the district council. May I pause here, my lord? So courts are constituted by the district council under the 1953 rules. But those courts cannot exercise the power unless the governor confers that power. It does not constitute the court, but it only confers the power for trial of cases of 5 years above to the district council in any behalf, and such power under the CRPC as it deem appropriate.
One thing, Mr. Ansara, one thing which struck me earlier on,
yes,
was this thing, okay, confer on the district council, original council having authority over such district region or on courts,
yes,
constituted by the governor,
yes, or on courts constituted by district council.
So, such council. Now, is it a rider or on any officer?
Yes,
can
Lord.
It be anybody?
Yes, it can.
Can it be anybody?
It can. It can.
Mr. B, we confer on you the power.
No, Lord. If that case arises, Lordship would decide it in an appropriate case. But
that's just for the.
In a theoretical matter, yes.
Here,
the reason derive
the benefit.
Yes, my lord. The reason is, my lord, in 1950, district council courts are not constituted. It is at that stage the constitutional makers thought that it will be vacuum, because under the 1937 rules are applicable. There the additional deputy commissioner decides. So till the district council courts are constituted, some officer has to decide. So that is why, my lord, so far the tribals are concerned, the governor has been given the power to give it to any other authority. And this continues.
This continues. So now even today also the government have the power to
say yes, in para 5 I appoint X to decide cases, but he has not done so, and if he does so, it will be struck down by our lordships on various other grounds. But these are theoretical. I am not making any submissions. If the district council,
you see, it's just a thought that crept up. You know, the thing is that on any officer.
Yes, lordship is right, my lord. Theoretically, under paragraph 5. The governor is empowered to appoint any other officer to try cases between the two scheduled tribes. But there is no such notification. There is no such notification has always been.
Because you see, one thing is the conferment of power.
Yes.
Is also by designation, personal designator.
Yes, my lord.
For all district council.
On the
judges here.
Yes.
If you might be the judge in July.
Yes.
There's no conferment of powers.
Yes.
So they don't take up these matters, above 7 years.
Yes.
Right? So the thing is, in Khasi Hills, only Khasi Hills council where they confer specifically, like Mr. So-and-so.
Mr. So-and-so, judge district council courts. And with a designation, my lord. It does not say Mr. So-and-so, suppose they say Mr. So-and-so is appointed as judge. Well, that will be very difficult for them to sustain. They have not done it. State has not done it. Suppose they say Mr. X sitting in this court will be the judge district, so they decide.
That will not be equivalent to any person, because they're given by personal designation, by designation.
My lord, here, yes, it is by designation, but always has been, because that has been the understanding of the constitutional scheme by the state, by the courts, by the Supreme Court, by all of our lordships, that the judge district council court by person, because the requirement is that the power has to be conferred on a judge. That is why by personal name. And I'll show you notifications, my lord, in this compilation right from, my lord, beginning till after this CRPC is applicable. It is by name, powers are conferred on the judge district council courts to try cases under paragraph 5. Though theoretically your lordship is right, can be by any other person, but I haven't got any.
Because all officer means officer, okay, might be whatever.
Or any officer appointed in this behalf.
Yes.
So he can appoint my learned friend as an officer to try the cases of two scheduled tribe, my lord. Theoretically, yes, but it has not been done. And the reason is, my lord, why it has been done at that stage. There were no district council courts. I also thought of it, my lord. Why it has been said there were no district council courts, and the constitutional maker did not know.
This struck my mind also that.
No, your lordship is right. It is definitely struck anyone's mind why the power has been given when it is. But then your lordship's court and the Supreme Court consistently said only district council courts.
And the very fact that it's not given to a court.
Yes.
By itself, like the district sessions judge, tribal by so and so.
Yes.
It's by personal conferment. That makes it a very special kind of conferred jurisdiction. That is why the question.
Your lordship is right, my lord, because we do not know 53 would have been made, or 63, or 83, or 93. Till then, somebody has to administer justice. That is why, my lord, because these 1937 rules, deputy commissioners should decide. All right, instead of deputy commissioner, they could have said some officer who knows with the tribal laws, tribal custom, tribal environment of the area. The constitution makers, that's why they kept that provision, any other person appointed by the governor. Theoretically, your lordship is right. What is important is, my lord, subparagraph clause 3 thereafter. And it, my lord, what I'm rephrasing it again. that the courts are not constituted under para 5.
Yes.
Courts are constituted by the district council after 53 under the 53 rules, and the governor, but those courts cannot exercise power of 5 years above unless there is a conferment of power, and there has always been a conferment of power. Series of notifications are there in this compilation, and any other power, it is my submission, it is to fill a stopgap arrangement. The constitution makers thought so as a stopgap arrangement. Now para 3 is important, clause 3 sub para 3 is important. Save as expressly provided in this paragraph, that is conferment of power, CRPC shall not apply to the trial of suits, cases, offences in an autonomous district and in an autonomous region to which the provisions of this paragraph apply. So CRPC cannot be applied. There is a constitutional bar. You cannot take away the constitutional bar by view of a mere notification. You require a constitutional amendment to apply CRPC to this to the travel courts, my lord. Now, my lord, if your lordship kindly see, having seen this, may I just show to your lordship the two sets of notifications. First, conferring power on the district council courts, which are in this compilation, page 179 onwards. Both prior and after CRPC applied to the state. 179 I have tabulated right from 89 to 2023. Lordship, see the language.
Yes.
In page 180.
Yes.
Merit. In exercise of power under subparagraph 1 of paragraph 5 of the 6th schedule to the Constitution of India, the Governor of Meghalaya is pleased to appoint Mr. Dakar, MA LLB, Judge District Council Court, who is hereby appointed by the Governor as the officer for the purpose of this paragraph, and the power of trial of offences punishable with death, imprisonment, or not 5 years. So, my lord, a judge, because it's a mandate, you cannot give it, and our rules also say that and it is first we select them, we send it to the governor for approval, governor approves the appointment and then confers the power. That is the scheme, my lord. Now similarly, my lord, page 181, identical language.
89.
Now what I wanted to show to your lordship is page 190 and 191. Now before, my lord, till page 189 or 4th February 2022, similar, my lord, for district, for the magisterial power, different notifications, for the sessions judge, different notifications. For example, page 189 is regarding magistrates.
Yes.
In exercise of power under Rule 7 of the 1953 rules, the Governor of Meghalaya is pleased to approve the appointment of so and so as the magistrate first class, and they will further the Governor of Meghalaya in exercise of power under paragraph 5(1) approve the appointment, confirm the appointment of so and so as the magistrate of the first class along with the power of the judicial magistrate of the first class as appointed for trial of cases, etc., etc. Now, my lord, in between there comes the 2022 notification, 2022 notification, which is at page 177, by which CRPC is made applicable on 20th September 2022. Now what does it say, my lord? It's very carefully crafted and rightly so that it can uphold, it can be upheld by the courts. In pursuance of full separation of judiciary from the executive and in exercise of powers under CRPC, subsection 2 of section 1 of CRPC, the Governor of Meghalaya, he is pleased to apply the provisions of Code of Criminal Procedure to the courts in the state of Meghalaya. No difficulty, but courts every. Now, district council courts shall continue to derive their powers under paragraph 4 and 5 of the 6th schedule to the Constitution. What is the necessity, my lord? If they say everything, it is applicable to everyone. This line is odious, it's not necessary. That's what your lordship, my lord, just thank you, has said in a recent judgment in Philip, that this takes out the notice from, so far as the applicability of CRPC is concerned to the district council courts, this line takes it out, and under the constitutional scheme it takes it out, my lord. Now after this notification, now lordship may kindly come to, my lord, page 190. So if they say after this district council courts cease to exist or they have no powers, then, my lord, 190 notification is why they have issued, my lord, lordship would kindly see, that is the requirement. In exercise of power under Rule 9 of the District Council Administration, so and so, my lord, the Rule 9 says that appointment of the judges, District Council Court, the Governor is pleased to approve the promotion and appointment of so-and-so, Srimati so-and-so as the Judge District Council Court. Further, in Governor of Meghalaya, in exercise of powers conferred under subparagraph 1 of paragraph 5 of the 6th schedule to the Constitution, is pleased to confer on Srimati so-and-so, Judge District Council Court, for the power to try offences punishable with death, transportation for life, imprisonment for a term of not less than 5 years of the Indian Penal Code or any other law for the time being in force applicable in the Khasi. So, Judge District Council Courts have been conferred the power after that to try cases under paragraph 5, and 191 is a subsequent notification.
Yes.
Be which additional judge. There can be Judge District Council Court, there can be additional Judge District Council Court, and both as the simultaneous powers and coextensive powers. Then your Lordship would kindly see the set of notifications regarding conferment of power on the judicial officers. That's also very interesting, my lord, which your Lordship would find from page 192. Lordship would give me a minute.
Yes.
Because, my lord, even after separation of judiciary, since 1937 rules are in force, which confers the power to try cases to the Deputy Commissioner or additional Deputy Commissioner, all that the state says, there is a judicial officer and confirming his power of ADC. He has not been directly conferred by force of CRPC.
Yeah.
Now, page 193, Lordship may kindly see, my lord. In exercise of power under Rule 1A of the Administration of Justice Rules 1937, I have read to your Lordship that the Governor can confirm the power. And further under Section 2 of the District Just of the Administration of Justice Act, the Governor of Meghalaya, with the approval of the High Court, is pleased to appoint Srimati Giri, District Assistant Judge, as Additional Deputy Commissioner. May I pause it here, my lord. So, my lord, what has been done is a judicial officer, with the consent of the High Court, is been appointed as Additional Deputy Commissioner so that she can try cases of non-tribals. So, for tribals are concerned, my lord, 37 rules are repealed by the 53 rules.
Right.
So, that Additional Deputy Commissioner no longer has power under the to decide cases between the tribals. It is only the district council courts.
Right.
So, my lord, that's why the judicial officers are appointed as Additional Deputy Commissioner to for the trial of all cases, offences punishable with death, imprisonment for life, imprisonment for etc., etc., etc. So similar notifications are there, my lord. 193, 196.
Right. That yes, you are aware.
Up to, my lord, 201. Now, my lord, this 201 notification came to be interpreted by this court in Commercial, and this court said, in view of this 3rd May 2018 notification, the regular courts will have power and not the district council courts. I'll show that.
3rd May?
3rd May 1918 to 2018, page 201. Page 201. I'll show that also, my lord. In exercise of power under Rule 1A of the Administration of Justice Rules, and further under Section 2 of the so-and-so, because, my lord, it refers also, and para 5 of the 6th schedule of the Constitution, is pleased to confer on the district and session judge with powers of Additional Deputy Commissioner. It does not say with the powers of the district council courts.
Yes.
It does not say powers of the tribe to be tried between the two tribals. For trial of all offences punishable with death, imprisonment, etc.
I mean, Additional Deputy Commissioner, means it's also 37. It's application of 37 rules only.
Yes, my lord.
That is a given.
Yes, my lord.
That's the given.
Now,
yes,
but this court, my lord, interpreted this in Commercial, that is in the second compilation, to say that even between the tribals, the regular court, the additional district judge can exercise jurisdiction, because this language here there is a mention of paragraph 5. And it is after, and the judgment was after CRPC being made applicable. Now, can I just show your lordships the judgment in Commercial?
Yes.
And in this compilation, I just have to show one more document, Lord. I am done with this compilation. The last document in this compilation, page 211, by which BNSS, Bharatiya Nagrik Suraksha Sanhita, has been made applicable, but with a similar rider.
Yes.
In exercise of power under subsection 2 of section 1, Bharatiya Nagarik Suraksha Sanghita, the Governor of Meghalaya is pleased to apply the provisions of BNSS to the courts in the state of Meghalaya with effect from 1st July 24. The District Council Court shall continue to derive power under paragraph 4 and 5 of the 6th schedule to the Constitution. It's identical to, my lord, CRPC being made applicable. Now, would your lordship kindly see, my lord, how these two notifications had been interpreted by your lordship, my lord, in a recent judgment in Philip case, which is a compilation, my lord, of the second compilation. The judgment is at page 128, where my Lord Justice, thank you, is also a party, sitting with my Lord the Chief Justice, the then Chief Justice.
128.
128, the judgment starts. The judgment challenges 3 notifications. And that's why my learned friend Mr. Amit Kumar, Advocate General, is relying upon in his submissions. He has made a reference of this. So I am taking your lordship first to this judgment and then the other judgment. 3 notifications issued by His Excellency the Governor has been challenged. The first is applying BNSS, CRPC, 20th September 2022. I read to your lordship, my lord, which says that District Council Court shall continue to derive power from para 4 and 5. The second notification is of 2021, whereby the power has been given to the District Council courts. Perhaps it was on the presumption that the District Council did not recommend. But my lord, I have materials, my lord. It is appointment is by the District Council, approval is by the by the Governor thereafter. And the third notification is, my lord, appointment of similar to what I have read, is pleased to appoint, page 131, line about 7, in exercise of power under rule so and so of the 37 rules and section 2 of the Meghalaya so and so rules and paragraph 5 to the Constitutional Governor of Meghalaya is pleased to appoint additional district session judge as additional deputy commissioner for trial of offences for 5 years plus. Now, after noting these 3 paragraphs and noting the submissions of the parties, my lord, in para 6, lordship notes our side contention of Khasi Hills Autonomous District Council, saying that there is a conviction judgment which is stayed by the Supreme Court, and what your lordship's conclusion is in para 8. On a plain reading of these 3 notifications, it does not appear to us that the Governor has exercised his jurisdiction in extending the provisions of section 1(2)(b) of BNSS. The state government is entitled to extend the provisions of the state code to the tribal areas. The only conflict arises is whether by reason of paragraph 5, subparagraph 3 of the 6th schedule, the provisions of BNSS and BNS will apply. The notifications are carefully drafted, as would appear from these notifications that paragraph 5, subparagraph 3 of the 6th schedule has not been touched, and constitutional rights enjoyed by the district councils have not been impaired by such notifications. But after this conclusion by the division bench, I don't think Lord State is able to say today, by way of BNSS being applied, by way of CRPC being applied, district council jurisdiction goes. Your lordship has negated that. Further, my lord, your lordships also records, moreover, by reason of the judgment of the Honorable Supreme Court in Melvin, in the absence of a notification by the state extending CRPC to tribal areas, the provisions of CRPC are not applicable to except so and so. The state government has now, instead of issuing notification, extended the benefit tribal areas. However, the state was careful in not imposing the district council courts the mandatorily apply BNSS. So, my lord, your lordships, while interpreting this BNSS notification and the notification extending, giving the power to the district council courts, and the notification giving it to the judicial officers appointed as the additional deputy commissioners, hold that so far district council courts are concerned, their powers have not been touched because they continue to apply. Now, my lord, 2 questions arose, my lord, to earlier in Melvin case, which earlier, my lord, which was transferred in a similar circumstances, transferred by your lordship's court from the regular court to the district council court. The state went to the Supreme Court, and the state, my lord, the judgment is at page 70 of this compilation. State of Meghalaya versus Melvin.
Page 70.
Page 70.
Yes.
It was also a case, my lord, of section 302 IPC, punishable with death. Paragraph 2, However, on the basis that the parties in the instant case are both tribals and thus case exclusively tribal by district council courts, the accused preferred a petition for transfer of the case similar to the present set of petitions and they sit to the judge district council court Shillong. While the impugned judgments of 5/12/1971, that judgment is also here, my lord, at page 68 of your lordship compilation. The High Court of Meghalaya Shillong allowed this petition. The instant SLP has been filed against this order of the High Court. At the very outset, it is important to note that the area where the alleged offence is committed has occurred in the West Khasi Hills is a notified autonomous district included in paragraph 12 of the 6th schedule of the Constitution, which deals with the administration of tribal areas in the state of so and so. As specifically the aspects of judicial dispensation in such area is para 4 and 5. Para 4 and 5 are quoted, my lord. Then, my lord, they are in para 5, the respondent accused contenders are noted. Para 4 notes the state contention that, my lord, the regular court would apply. Para 5 notes the accused contention that the district council courts will apply. Then, my lord, the court consideration is para 6, 7 and 9. 6. Upon consideration of material on record, the argument advanced by the parties and the central issue is that for our considerations whether the criminal case against the respondent is exclusively triable by district council having regard to the scheme of paragraph 4 and 5 of 6th schedule. Then, my lord, the CRPC is quoted and lordship may kindly see para 7.1. I must bring to your lordship notice that was a case where CRPC was not applicable. But your lordship has clarified that does not matter so far as district council courts are concerned. As seen above, the expression tribal areas occurring in section 1 CRPC refers to the area indicating 5th and 6th schedule. In the absence of a notification by the state government extending CRPC to the area, except the 3 chapters referred above, the CRPC is not applicable. Now it is applicable, my lord. Now, para 10.4 is the conclusion. Such a reading of the term cases is also substantiated by the fact that only para 5 only empowered the governor to make CRPC applicable to those cases where punishment is offence for more than 5 years IPC. By necessary implication, the governor is not authorized to invest any of the bodies mentioned in para 5 with the powers of CRPC for offences punishable with less than 5 years. Reading para 5 in conjunction with para 4 inevitably lead to the conclusion that all criminal cases are triable by the courts under paragraph 4, irrespective of the fact that D0 complaint in the state is both by the accused and victim are the scheduled tribe. So, my lord, it upheld this honorable court notification. Now, whether any change has been made by the application of CRPC, my lord, Commission to some extent deals with it, my lord. May I just refer to your lordship the Commission judgment, which is in page 87 of this compilation, a division bench judgment of this honorable court.
That has noted the change.
Yes.
87.
Yes, my lord.
Yes.
And here in this judgment, my lord, I'm sorry, my lord, my learned friend is right. I should have read para 10 point, page 75. I should have read para 10.6 also in page 75. I'm so sorry. In the instance case, it is an admitted position that the victim and accused respondent both belong to Khasi scheduled tribe. Thus, given that there is a specific notification of 2017, similarly, my lord, even in 2023, confers district council court with the power of CRPC to try certain offences, we find that such conferment should be given effect. In fact, upon a combined reading of paragraph 4 and 5 of 6th schedule, such district council courts have exclusive jurisdiction to entertain such a case, which is a case more than 5 years. Because of the notification and such notifications.
No, I don't think it says like that, Mr. Nandi.
Yes.
Para 4 we have no quarrel, but
no,
para 5 is.
Para 5, my lord, that's why, my lord, I am trying to read, my lord, this is a case dealing with para 5. This is a case dealing with death sentence cases, my lord.
Right. Yes.
The Melvin case is a case dealing with death sentence case. Now, your lordship, my lord, in Commission also dealt with a case, my lord, where 302 was involved. And your lordships noted, my lord, at page 95, para 24, that the CRPC is now applicable.
Yes.
Para 24, Lordship note that by 20 September 2022, CRPC is not applicable. Now it refers to, my lord, thereafter the notification of the state government of 3rd May 2018, which I read to your lordships in para 33 or 34. 33 and 34.
Unsubstantiated.
And my lord, may I read from 32 what fell from my lord, my lord. Yes. Similarly, there is no limitation on the power of the governor in conferring power to the authority, say pertaining to the IPC, to a particular court or officer appointed in this behalf. No quarrel, my lord. If the governor does it, we'll see whether it happens, what happens. In that behalf, some other special law appointed in this behalf, the plain and wide amplitude of paragraph 5 to the Constitution cannot be hedged with such enormous condition that an authority being required to be conferred on one court or officer, the authority once conferred not being capable of being modified in part of or carve out a class of matters to be placed before an altogether separate court or officer. My lord, no quarrel on that. But where is that, my lord, notification that I am conferring power under para 5 for trial of district for scheduled tribe people to a officer or to the regular court?
Yes, that is.
Then, my lord, 33 refers to, my lord, that notification by which the district judge was appointed, given the power of ADC. And this court in para 34 held. However, in view of second paragraph in both the notifications, which I read to your lordship, lord, in 3rd May 2018, the earlier notifications pertaining to the serious crime with revoid district sense superseded, and the power previously conferred to the district council court to a particular officer can no longer be exercised to the extent that it has been superseded. So that is the finding of our lordship's court. And para 38, my lord, page 99, for the reasons aforesaid, there is no merit in the objection raised by the appellant as to the jurisdiction of the trial court in the case conduct by the criminal trial, adjudicate the matter and pronounce its judgment and order thereon. Therefore, in terms of the 3rd May notification, the office of the district assistant judge as specified by the Meghalaya rule was vested with the power to try the present cases involving death sentence. Lord, that is what you are finding of your lordship's court. Lord. If this judgment is there, I have difficulty. Now, this judgment was challenged by the district council, and your lordship would find the Supreme Court order at page 107. And by detail order, normally, my lord, Supreme Court just say issue notice and stay, but here, my lord,
para 34 has been.
Yes.
Yes.
34, so and so council does not represent either so and so, para 5 of that order. The council submitted when both the victim and accused are local tribal, the district council court is competent to try offences punishable with death, imprisonment for life. This was indicated in the Meghalaya government notification of 10/8/2011, Annexure 16, the series of orders, my lord, which I showed to your lordship, my lord, from pages 179 to 191. This notification is also there. Issued in exercise of power under Rule 9 of the 1953 rules. The Senior Council refers to the ratio of Melvin case, where a similar issue on the jurisdiction of the regular district council court for the trial of offences punishable with death, imprisonment not less than 5 years. This court approved the decision of the High Court, which declared that the case is exclusively triable by the district council court. The relevant observations of Melvin is quoted, my lord. I am not troubling your lordships. Then para 6, with the above, the learned council submits that while the district council is directly not interested in the outcome of sessions case, the direction in the impugned judgment dated so and so upholding the said judgment is coming in the way of functioning of the district council court. The same is now happening for the trial of serious crime in the judicial area. The division bench of the High Court, while upholding the conviction, has recorded the following observations. Now, para 34 and 38 I have read to your lordships. Mr. so and so argues that in view of the special provisions made for the concerned area in the district, Meghalaya districts, in those cases where both victims and accused are local tribal, the trial has to be conducted by the district council court and not by regular sessions court. Issue notice, meanwhile, this is stayed.
What happened? Now, Ms. Ansari, what happened to the case now?
Page 10. Para 10. In the meanwhile, yes, the operation and observations made in paragraph 34 and 38 of the judgment in Commission are stayed as an interim measure.
So
Now,
by the time this matter is heard,
no, it was listed before in July, my lord, because both of us has difficulty. I annexed those orders. If your lordship kindly see page 111.
yes.
After, my lord, my learned, the state government appeared. The leave is granted and order is confirmed. This was an ex parte order. Now, after, my lord, the state appeared. After them, their leave is granted and appeared. And, my lord, now it was listed in the vacation. And it is directed to be listed, my lord, in July itself after 4 weeks for final hearing, these cases. Now, my lord, I must point out to your lordship, my lord, on an earlier occasion, this court transferred a case from the regular district court to, from the district council court to the regular court. Because, my lord, in that case, the district council court convicting a person in 302 gave 7 years imprisonment. They said that your lordship said, my lord, what is this happening? And then we can't trust and we are transferring it to a regular court. That order was also stayed. I must show to your lordship in this compilation itself, my lord. Only for that purpose that the Supreme Court has been repeatedly saying, my lord, that it cannot go, whatever it may be, it cannot go to the regular courts.
Non-negotiable, you mean?
Non-negotiable. Not negotiable, because that is the constitutional scheme. That is the constitutional scheme. If your lordship kindly see page 58, judgment of this court, my lord, a division bench judgment, where in para 17 and 18, your lordship says it is unsafe to remand to the district council court. Because even after conviction, if you give 7 years, it's unsafe. But then Supreme Court said not negotiable. Para 17, for what has been noticed here and above, we find it unsafe to remand this matter to the district council court for fresh proceedings and deem it appropriate in the interest of justice. My lord, they don't have 142 powers, my lord, that they transfer it. Your lordship does not have. Hand over to the competent sessions court, we deal with them similar. Accordingly, the appeal is allowed and stands withdrawn from the district council court and handed over to the court of session judge in terms of the order. Now, this is again challenged by the district council. Page 65, my lord, notice is issued and this order is stayed. Then, my lord, in the page 66, after hearing the state, leave is granted. And in page 67, in the vacation, both these cases, my lord, conviction and this judgment, both were listed on 1st of July. And the order is, my lord, in view of the letter circulated so and so, adjourned for 4 weeks. So it will perhaps come in July or August, my lord, for hearing. So, my lord, my submission is, my lord, that first, my lord, the constitutional scheme is that the district council courts alone will have, but if it is para 5 years plus, you have to be conferred power. Yes. That power has been, what is important, the state has conferred such power even after application of CRPC. That so state is aware of it. And while applying CRPC, it specifically says it does not touch the powers of para 4 and 5. And that's what your lordships has interpreted, my lord, in a recent judgment, my lord, which I have shown to your lordships.
Yes.
In the Philip case. My lord, what is also said is by the judge.
So in the intervening period till the matter is decided, because 34 and 38 are two contentious paragraphs.
Yes.
Of the fighting of the division bench, where we are bound. If yes. that is upheld or interpreted in some other way, then where would we leave? These people all stuck. All appeals are, pending. We can't hold these matters any longer.
Today the law, tomorrow what happens, yes. You do not know. Yes. Today the law is, before your lordships, these are the cases, my lord, before 2022. Bulk of the cases in your lordships board today are before the 2022 CRPC applicable. 1 or 2 cases are post that also. So far before 22 is concerned, my lord, this Supreme Court judgment in Melvin is very clear. Post 2002, first Supreme Court stayed, and your lordship has specifically said, my lord, in the Philip case, that it cannot go to the notification clearly says paragraph 4 and 5, district council courts are clearly safe. So today, my lord, the trial cannot go on before it will be before a non-jurisdictional court. And there are cases, my lord, where some cases were sent to the fast track courts, my lord, when the fast track courts were there, which were constituted.
What he was asking was what should happen to the trial? It should go back to the district.
No, the trial has to be conducted by, there are district council courts which are functioning. What is happening with the state? And your lordship, I would request your lordships, if your lordships are with me, lordship will issue an administrative order, direct the registrar of this court to issue an administrative order that all the regular courts will if it comes to them, they will send the cases, which is the mandatory requirement, to the district council courts, my lord. If your lordships are with me. If your lordships are not with me, my lord, that's a different issue. So, my lord, what I am saying is, my lord, there's one more judgment where the case was transferred to the fast track court, my lord. which is a regular court. Your Lordship says fast track court or no fast track court, not negotiable. It has to go to the district council court. And this is also a judgment of 2020.
Where the matter, was discharged from this council court on a filing by the victims, matter was taken to fast track court, persons convicted. So there are many instances also.
In that case also, and it has to be de novo trial, my lord. What the court say, what the contention of the state was, all right, evidence has been partly recorded, let it be done. What your Lordship said, this is a court without jurisdiction. So this, you have to start a de novo trial, and in that regard, my lord, I want to show to your Lordship one more judgment, which is at page 112 of the same compilation. Here also, my lord.
Yes. De novo trial.
Paragraph 5 and 6 records, a case was transferred to the fast track court, my lord, because FTCs were functioning. It was a case of 376, and your Lordships, my lord, referred to Kumerchand at para 25 at page 118. And after referring to Kumerchand, they say it is not applicable. Then para 27 to 29, on reliance by the learned additional advocate general, the provisions of 462 and 465 CRPC to say the proceedings of the fast track court are valid only for the fact that the same was done in a wrong place or jurisdiction. Therefore, district council court is otherwise competent to pass judgment on the basis of such proceeding. The very fact that the fast track court, which has relinquished its power to try cases in the first place, apparently by its own admission that it lacks inherent jurisdiction to try cases, the learned district council court, on the premise when the matter is transferred to its court by directing de novo trial, the same was done in consonance with the accepted jurisprudence principle of subject of jurisdiction. Therefore, there is no illegality. Then para 29, in any case, once the case is established, it is established that the fast track court lack jurisdiction to try cases, the same being transferred to the district council courts, it is incumbent upon the district council court to restart the trial, to take place de novo, the action of the learned district council court to take up the trial to case from whom the stage left by fast track court has vitiated the whole proceeding as such case, an impugned judgment is liable to be set aside. This judgment is not challenged by the state before the Supreme Court. So, my lord, their lordships have consistently, my lord, let me sum up by saying, lordships have consistently held that when both parties are there, it is to be tried by the district council court, provided there is a conferment of power. It is not a constitution of court, it is only a conferment of power of a court already established by the district council under the 53 rules. And the new notifications of applying CRPC and BNSS does not help, my lord, to the state, because it saves the otherwise, my lord, the entire notification would have been liable to be challenged. It has not been challenged. Once it is challenged, and your lordships in paragraph 8 of that Philip case said that no, para 4 and 5 are saved. It is kept out. That is the purpose. So, my lord, my respectful submission would be, my lord, these are the trials of 2019 or thereafter to 24. They are being stayed or they are not being proceeding. There are district council courts on whom powers have been conferred, page 190, 191. I have shown to your lordship even after CRPC being made applicable. So those courts alone will try the cases. Lordship would try transfer all these cases, direct the on the administrative, the High Court, that they must issue direction that no regular courts would entertain where both the parties are tribals, and also to the state, that the state, my lord, what is happening today, state produces before the regular courts and they start trying it.
No, that's not a question.
Yes.
What is the trial? Now, proceeding before that, the trial commences, it comes to the council court. So all the production, everything is done. The question of, all the proceedings.
No, production is all right, my lord.
Done before the regular
police first produces the before the magistrate.
Yes.
Then it's magistrate's duty. If it finds that it is tribal by district council courts, it sends the cases to the district council courts. First, it is produced before the regular magistrate because the police may not know which period, what is there. So it produces before the magistrate. Magistrate duty is, if you find both sides is scheduled tribe, then para 5 applies, and it must be tried. And that was, my lord, happening last
It's been happening, yes, but I think
that has all been happening, my lord.
Another practical consideration, Mr. Ansari, is the expediency. I mean, the expeditious trial of case.
Yes.
Now, what has happened is that there's a lot of backlog.
Yes.
There's sort of what you call a deadlock, in the sense that district council courts, the speed, or at the the motion at which the trial goes, like by the time the matter comes for, it's like the witnesses are not available, they're forgotten, and so we have to have that, because for the victims we have to.
Well, today, my lord,
that is also
today we have sufficient number of judges. We don't have cases, my lord. I've taken the instruction. We have this. They require only one district council court for trial of session. My lord, we have 3 from post. One district council court is there. One additional additional judge district council is already appointed. So by the 3rd is concerned, the process is there. My lord, of course, it go through the regular selection process and appointment and approval of the governor, and goes to the High Court also. My lord, after that they are appointed. So there
High
is.
Court for information only. We don't have any. We don't exercise any administrative power over the appointment of district court.
No, my lord, that all, my lord. Just a minute. Well, lordship would give me a minute. But I am told, my lord, when the judge district council court is first, my lord, there are service rules in which judge district council court is one of the class 1 officers. District council selects MA, LLB, etc. After selection, it sends to your lordship's court, my lord, High Court, for confirmation. Once the High Court confirms, it is sent to the governor for approval. Once the governor approves, and then the power is conferred.
I will not go into that. I don't think
no, lordship may not, my lord.
No, it's not the correct position. Anyway,
my lord, that may not be required, because I'm saying what, since your lordship posed me, I also asked them yesterday conference. They say it goes, but my lord, that need not be, because what the district council appoints, but your lordship has seen the notification at page 190 and 191. Governor approves it and then confers the power, but governor does not appoint, my lord. So there is no question of
that is there in the section.
So there is no question of regular courts trying, my lord, and the state has been saying since 2007 also there is a judgment, 2017 there is a judgment, 2020 there is a judgment, 2024 there is a judgment. State's contention.
Suppose, Mr. Hansara, just for discussion's sake, suppose tomorrow the court the governor withdraws the conferment of powers to the district council judges now.
Yes.
And says that, okay, fine, henceforth the cases are pending, let it be tried. Can it be that that position can be arise? We take away the conferment of powers. Like in Giant Hills and Garowals, I think there's no conferment. It's done by regular courts.
I understand.
Can that situation arise also?
In a given case, theoretically, yes.
Theoretically, yes.
Theoretically, yes. If that does, it will be subject to challenge.
Exactly.
And your lordship would suck it down. The reason is this.
Yes.
The reason is this, my lord. Why these district council courts are constituted for last 73 years, Lord? Today, what is the new situation? Theory of arbitrariness will arise. The theory of proportionality will arise. Why today, suddenly, we have backlog in regular court for 20-year trial, 30 years trial. Does it mean that you give it to the the administrative officers? Suppose, Lord, there are cases pending for 30 years in the regular courts. Tomorrow, can the government say, or even the constitutional makers say, even a parliament say.
I feel that, what has happened is a consideration of these facts. That's the only thing that, to for speedier trial, that's all. Maybe that is the maybe policy thing.
Look, the speedy trial
cannot. The way it has been executed, we don't know. Maybe we should empower the council courts more, give them more funds or whatever,
that's a very big issue, my lord, with funds, etc. Are big issues with the district council court. But today, my lord, I can say they are functioning properly. 1 or 2 exceptions have been there where they have performed badly. This court said it's unsafe to try, but Supreme Court said no, we repose confidence and they will only try. So, my lord, they will try. My lord, if one officer is bad, we have found that officer even in the regular courts. My lord, one officer is bad, is not competent enough. Does not mean, my lord, in a skin to skin case, even a high court judge, my lord, in the skin to skin case. Says that lordship knows what, and the judge was not continued. My lord, that's a different story. But then one judge is not able to perform or able to discharge, my lord, it does not take away the constitutional jurisdiction, my lord, of a particular category of courts, my lord. In my respectful submission, lordship would transfer all these cases, my lord, and direct expeditious trial. We will instruct our officers, my lord, to the extent possible, the state is to cooperate for the production of witnesses, etc. They will complete the trial, etc. my lord. And that matter, I'm extremely grateful to your lordship, my lord.
Thank you. Mr. Advocate General, you want to make any rebuttal? But not after, not now, at 2:15.
2:15. Yes.
Every 2:15.
Your lordship have, because now I have received all compilations and everything. Only I will preface, my lord. Your lordship may have it. Only two sentences, my lord. Your lordship may have. One, that there is no argument that the regular district and session courts have no jurisdiction to try the case. So
I think that is the first argument of mine, my lord, that they don't have.
Because district and session judges.
But that's the basis of Ms. Hansell's argument that has been repeated. 37 rules don't apply, and so yes.
No, the district at this point of time, Lord, in Meghalaya, the argument, in my opinion, should have been, according to me, that the district and session courts have no jurisdiction to try the cases after BNSS notification.
The advanced arguments will have it on when is it convenient? Next week?
21st or 21st, yes. Your lordship may have it physically. I'll try to do that.
Yes, you have your personal engagement. Yes. 21st. Not 21st, not on Tuesday. We'll have it on 22nd. 22nd. Yes. You can appear virtually.
Yes, please also.
Thank you.
I'm extremely grateful for patient hearing, Lord.
No,
which is a very scarce commodity in Supreme Court.
We have enough time. Thank you.
Extremely grateful, Lord.
Thank you, sir.